So the 20 minutes later, we will start.
20 minutes? Okay. Yeah. Good.
And, so I heard in the
Hello， 英文 testing 1 2 3 英文試咪1 2 3英文 Hello 1 2 3英文 Hello
英文 OK 啦，而家廣東話。
好。
Good morning. The workshop will soon commence. Please be seated and mute your mobile phones and other electronic devices. The workshop will be conducted in English with separate channels for simultaneous interpretation in Cantonese and Mandarin. You may pick up your headsets at the entrance of this room. For online participants, you may choose to prefer language by clicking the language button on the sidebar. It is recommended to use headphones for better sound experience. 大家好，工作坊將會以英文進行，並設有粵語同普通話即時傳譯。參加者可以喺房間入口取用翻譯耳機，而線上觀眾可以喺直播平台點選欄上嘅語言按鈕，選擇收聽語言，並戴上耳機收看節目。大家好，工作坊將會以英語進行，並設有粵語和普通話即時傳譯。參加者可以在房間入口取用翻譯耳機。在線上的觀眾可以在直播平台點選欄上的語言按鈕，選擇收聽的語言，並戴上耳機收看節目。謝謝各位。 Good morning, ladies and gentlemen. The workshop will begin in 5 minutes. Please be seated and mute your mobile phones and other electronic devices. Thank you. The workshop will be conducted in English, with separate channels for simultaneous interpretation in Cantonese and Mandarin. You may pick up your headsets at the entrance of this room. For online participants, you may choose the preferred language by clicking the language button on the sidebar. It is recommended to use headphones for better sound experience. 工作坊將以英文進行，並設有粵語同埋普通話即時傳譯。參加者可以喺房間入口取用翻譯耳機，而線上觀眾可以喺直播平台點選欄上嘅語言按鈕，選擇收聽語言，並戴上耳機收看節目。工作坊將會以英語進行，並設有粵語和普通話即時傳譯。參加者可以在房間入口取用翻譯耳機，而線上觀眾可以在直播平台點選欄上的語言按鈕，選擇收聽語言，並戴上耳機收看節目。For media who are present at the venue, please proceed to the media zone outside the venue after the workshop for any media questions. Thank you. The Honorable Ms. Teresa Chang, GBM, GBS, SC, JP, distinguished speakers and guests. Ladies and gentlemen, welcome to the workshop on Online Dispute Resolution, ODR, an efficient and cost-effective dispute resolution mechanism for cross-border disputes for ASEAN trade, organized by the Department of Justice of the Hong Kong SAR government. A very warm welcome to all participants, both in person and online. My name is Eunice, your MC today. Without further ado, may I first invite the Honorable Ms. Teresa Chang, Secretary for Justice of the Hong Kong Special Administrative Region of the People's Republic of China, to deliver the opening remarks. Let's welcome Ms. Chang.
Distinguished guests, ladies and gentlemen, good morning. On behalf of the Department of Justice of Hong Kong, China, it is my great pleasure to welcome you all to the workshop on online dispute resolution with the theme, an efficient and cost-effective dispute resolution mechanism for cross-border disputes for ASEAN trade. With this workshop being the first phase, we plan to organize the second phase of this workshop when travel restrictions have hopefully eased next year, in order to welcome you all participants from the ASEAN member states in particular, together physically here in Hong Kong. Despite the global downturn brought about by the COVID-19 pandemic last year, in the age of digitalization, e-commerce transactions have grown exponentially worldwide with the extensive use of the internet to conduct business transactions remotely. Under the Free Trade Agreement and the related investment agreement between Hong Kong, China, and ASEAN, a cross-border trading between Hong Kong and ASEAN continues to flourish. The total value of merchandise trade between Hong Kong and ASEAN has grown to Hong Kong dollars 1,034 billion in 2020, with total merchandise trade growing 1.6%. The growth in trade, especially through regional e-commerce, has inevitably led to more cross-border disputes. Traditional means of resolving disputes by cross-border litigation is not a real option for micro, small, and medium-sized enterprises, MSMEs, who often face financial constraints in hiring legal representation and struggle to survive a lengthy court procedure. Staggering legal and traveling costs, coupled with language and cultural barriers, pose great difficulties for traders to obtain access to justice through domestic courts. Thus, there is a pressing need to provide traders with an avenue to obtain access to justice in a time-efficient and cost-effective manner, and this is where online dispute resolution, ODR, comes into play. As a structured online platform, ODR automates traditional alternative dispute resolution methods such as negotiation, mediation, and arbitration, and may provide additional features to suit the needs of MSMEs. Expeditious and affordable ODR services will improve MSMEs' accessibility to justice and alleviates traders' financial burden. This, in turn, boosts business competitiveness and enables traders to explore new cross-border business opportunities. The acceleration of cross-border trade will enable MSMEs to thrive, expand their network into international markets, and contribute to the ASEAN economy. Following the adoption of the UNCITRAL technical notes on ODR, the United Nations General Assembly observes that, and I quote, online dispute resolution can assist parties in resolving the dispute in a simple, fast, flexible, and secure manner without the need for physical presence at a meeting or hearing. In 2019, the Asia-Pacific Economic Cooperation developed the collaborative framework for online dispute resolution of cross-border business-to-business disputes to help global businesses, in particular MSMEs, resolve business-to-business cross-border disputes, focusing on low-value disputes. On the ASEAN front, the ASEAN Economic Community Blueprint 2025 highlights the development of a regional legal framework for ODR for facilitating e-commerce transactions in ASEAN, Similarly, the ASEAN Strategic Action Plan for Consumer Protection 2025 also set the goal to enhance consumer confidence and cross-border commercial transactions through addressing cross-border complaints through ODR in its strategic goal 3. This shows that the growing importance of ODR in doing business within and with ASEAN cannot be ignored. It is imperative for ODR initiatives in Hong Kong to grow and be driven to assist in enhancing trade with ASEAN countries, as well as enhancing access to justice. To this end, Ibrahim has been established in Hong Kong to provide a full spectrum of ODR services to assist parties to resolve disputes via a secure and user-friendly online platform. We have also set up the Inclusive Global Legal Innovation Platform for Online Dispute Resolution, the iGLIP on ODR, in collaboration with UNCITRAL to keep track with the latest developments in the ODR landscape and develop innovative legal tools to address potential issues. We hope that our initiatives in contributing to an innovative and comprehensive ODR network will further facilitate the eco-tech collaborations between Hong Kong, China, and ASEAN. Finally, I would like to thank the ASEAN Secretariat for their support, and I hope to personally welcome you all to Hong Kong at Phase 2 of the workshop next year. May I wish you all insightful and fruitful exchanges this morning. Thank you very much.
Thank you very much, Ms. Chang. Please be seated. So there will be 3 panel sessions today. If you have any questions, please write them down on the question slips provided to you right in front of you on the table. Our staff will come over and pick up the question slips later on. For online participants, please type your questions in the chat box on Zoom. We'll address them at the Q&A session. For the first panel session on Introduction to ODR and its international and regional developments, we are delighted to have Dr. James Ding as our moderator and Mr. John Chung, Mr. Michael Dennis, and Professor Yoshihisa Hayakawa as speakers. Dr. Ding is the Commissioner of Inclusive Dispute Avoidance and Resolution Office at the Department of Justice, HK SAR government. Dr. Ding, the floor is yours. Thank you.
Thank you. Welcome to the first panel sessions of this workshop. We have 3 distinguished speakers for these panel sessions. They are Mr. John Chung, Mr. Mike Dennis, and Professor Yoshihisa Hayakawa. First, we will discuss about the value and the importance of ODR, and to elaborate to the businesses, in particular MSMEs, on how ODR could be useful for the businesses, in particular in relation to the cross-border trade in the ASEAN. Our first speaker is Mr. John Chun, sitting next to me. Mr. Chun is a very experienced lawyer, specializing in dispute resolutions and also with a lot of experience throughout Asia. He will give us a quick introduction about ODR and the importance of ODR for businesses in particular. We will then hear from Mr. Michael Dennis, an international ODR consultant, who will also tell us more about the importance of ODR for the businesses in cross-border disputes and also some of the relevant international developments. After that, Professor Hayakawa will tell us some of the latest ODR development in these regions and also internationally. I will introduce the speakers later on, and without further ado, I will pass the floor to Mr. Chung. John.
Thank you very much, James. Very good morning, everyone. Honorable Secretary for Justice, Teresa Ching, distinguished ladies and gentlemen. So the topic I've been given is leveraging ODR to enhance trade in ASEAN economies. So really, as a brief introduction, what is ODR? Online dispute resolution. Well, you heard from the Secretary for Justice, and in many ways, at its simplest form, ODR or online dispute resolution is a description of a form of dispute resolution that uses in whole or in part information communication technology. And if we can move on to the next slide, that's ODR. So let me give us all a simple example. This might involve the resolution of a dispute through a simple exchange of emails. So you see that on the slide at one extreme end of the spectrum, simply using emails. That's a form of information communication technology, and that's the resolution of disputes between two different traders, for example, in ASEAN and in Hong Kong. Or at the other end of the spectrum on the slide is the resolution of disputes through fully automated processes. So in simple terms, this means everything is dealt with online. You use artificial intelligence, algorithms, and the computer, the machines actually produce the final decision. You don't even need arbitrators like ourselves who will be jobless, but rather it is the machines, the computers who resolve the dispute and give you a decision at the end of the day. So rather than simply facilitating how you resolve a dispute, you actually have the software making the final decision. Now, for today's purposes, I will be referring to something that sits in between these two extreme ends of the spectrum. It's something more sophisticated, more advanced than simply an exchange of emails where you resolve a disagreement between traders, but yet it certainly isn't as advanced as using a computer to figure out the solution. So in broad terms, you see on the slide, ODR is a digital space in which parties use alternative dispute resolution mechanisms to solve a dispute, to solve a disagreement between traders. For example, when you sell a product cross-border to another jurisdiction, there's a disagreement as to the quality of the product that's been received, a disagreement as to price. This is when you use online dispute resolution as a way to facilitate the resolution of disputes. And what is unique about ODR is that you dispense with traditional paper-based forms of dispute resolution. You dispense with in-person litigation. You don't need to go before the courts to resolve the dispute, but rather it is resolved online without using traditional paper forms. As Secretary for Justice mentioned in her speech, ODR really, in many ways, facilitates the traditional forms of dispute resolution, which is negotiation, where you have a discussion with someone to try to resolve a difference, mediation, where you have a neutral third party to try to resolve a disagreement, for example, over price, or arbitration, where you have an arbitrator actually making the decision. You still use negotiation, mediation, and arbitration, except that this is done online. So this type of online dispute resolution, again, there's no fixed terminology or definition of it, but the various forms of it could include the use of digital case management, which means one files the documents, you initiate your claims online, there's electronic exchange of submissions between parties on both sides, payment of fees is made online, and there's a tracking of the caseload. So you can actually determine at what stage each dispute is online. So that is all done online. Or perhaps more familiar to many of us who practice arbitration, virtual hearings. That's certainly become very much the theme of the day in the last 1.5 years in this era of COVID, where instead of having in-person hearings, you have these hearings that are conducted remotely, in the same way that we have our fellow panelists joining us remotely today. Or, moving beyond that, you can have automated active assistance. So this is a more advanced form of ODR, where you're moving beyond simply using the platform to support the process, but you actually include some level of analysis in the platform. So the platform actually assists actively in resolving the dispute. So for example, the online platform might help to identify key issues in dispute between the parties. It might even suggest a range of settlement options. It might say party A is claiming for 1 million, party B is claiming for 2 million, and the sensible range of settlement options is between 1.5 and 1.7 million, for example. So that is a more advanced form of online dispute resolution. So how does online dispute resolution actually work? Well, let's move on to the next slide. How does it work in practice? So suppose you have a dispute. Now, a party may submit the dispute through the ODR platform. That's fairly simple. Importantly, they can use it over a mobile phone, and that's quite important in the context of MSMEs. So, because mobile phones, as we know, are so much more ubiquitous in ASEAN than computers, for example. Then after that, the platform assigns a case number, allows you to track what is going on in a dispute. You collect basic information about the dispute, details of the parties, the subject matter, of course, the amount in dispute, the nature of the dispute, the kind of relief that is being sought, what is being asked for by the disputing parties. This information then allows the platform to determine the legal issues, potential remedies which are in play. The platform, of course, serves as a communication device between the parties. It notifies the other side when is a deadline for them to put in the next response in resolving this dispute. If a negotiated outcome is achieved, the platform will help produce an agreement that records what has been agreed between the parties. If there's no negotiated outcome, the platform continues to assist in the process, for example, in appointing a mediator, a neutral third party to help resolve the dispute, or an arbitrator who will ultimately issue a binding decision, a legally enforceable binding award that will determine and finally resolve the dispute between the parties. So this kind of ODR platform I've just described, you may well ask, is it visionary? How long do we need to wait for it? Actually, a simple form of it is really very much in use in the large B2B and B2C e-commerce platforms, where they incorporate a simplified version of what I've just described in the form of an end-to-end dispute resolution service. And more recently, we'll hear about Hong Kong's own Ibrahim platform later this morning, and the HKIC, Hong Kong International Arbitration Center, has recently announced its Case Connect system. So these ODR platforms I've described are very much with us today and are ready for use. Now, moving on to the following slide, we've talked about how ODR works, and in the next slide, we will discuss why ODR is good for traders in ASEAN. And so we can move on to the following slide. Now, why is ODR good for traders in ASEAN? How is it particularly relevant to our situation? Well, ODR has the potential to radically change dispute resolution in the context of international trade. We're already starting to see that. Traders in ASEAN, as we know, they face significant difficulties when there is a difference of opinion or dispute, because these happen in a cross-border context. So your other trading party is another jurisdiction or country. The judicial process locally can be quite inefficient. There can be long delays between the filing of a claim and a final decision from a judge, and the significant enforcement risk. Because even if you receive a judgment in your favor from a court in ASEAN, you might then need to take the judgment and try to enforce it in another jurisdiction, for example, like Hong Kong. And that can be a long, lengthy, and expensive process. So moving on to the next slide, we'll see, well, how does ODR actually step in to achieve benefits? Well, there are four of them, in simple terms, on the slide. And it's, in essence, really a cheap, convenient, environmentally friendly process for resolving disputes. So first, ODR helps to reduce the barriers to entry. Now, the vast majority of disputes in ASEAN and in the region, in Hong Kong, are not disputes which go to trial. And the reason for that is because disputes are very expensive to resolve, especially for MSMEs. So by digitizing the process, we reduce the cost, we reduce the barriers to entry. Anyone can get onto a mobile phone and file the claim form electronically. You avoid the need for physical documents, you avoid the need to physically attend hearings, because this is all resolved online, and you have a one-stop shop for dispute resolution done cheaply and efficiently online. This digitization, of course, in the ASEAN context is very relevant, because ASEAN is a highly digitized community, as we know, and ODR helps to deal with different time zone and physical zone differences, minimizes business interruption. So that reduces the barriers to entry. A second benefit of ODR allows parties to bridge language and cultural divides. So trade disputes, as we know, tend to fit a fairly common mold. In some ways, they are fairly boring disputes, because essentially they involve disputes over non-payment, for example, or non-delivery, or delivery of allegedly defective goods. with a fairly predictable range of remedies and outcomes. This is where ODR comes in, because ODR is a real strength in resolving standardized disputes and building more efficiency into the platform and helping to overcome language and cultural divides in the process. So that's the second benefit. A third benefit, ODR provides a way to resolve disputes quickly and at relatively low cost. And here I'll just make the point that the research has indicated there is clearly higher user satisfaction when there's a quick resolution of disputes at a relatively low cost. And that is clearly important, again, in the context of traders. Now, by removing these time constraints in court processes, we're able to resolve disputes more quickly and to standardize dispute resolution workflows. And fourth, moving on to the last benefit here, really ODR helps us simplify the process of dispute resolution. In a usual international dispute, questions tend to arise over where the proceedings should be brought and which laws apply and how decisions should be enforced. But through the combination of alternative dispute resolution, mediation, negotiation, arbitration, and ODR, parties avoid many of these complexities and focus on what really matters, which is a factual dispute over what happened and who should be responsible for it. And remember, many of these ODR processes, including the e-commerce variants, build in enforcement into the platform itself because there is already a digital wallet in place. And once you have a decision, you have a credit or debit through the digital wallet or equivalents. So you don't even need to concern yourself with taking any decision and enforcing it across jurisdictions. So ODR really offers a relatively seamless transition between these different dispute resolution methods. You start with negotiation. If that doesn't work, within the platform itself, you then transition through to mediation and ultimately arbitration under the single umbrella of an ODR platform. And so in short, really, ODR has real significant advantages and it's certainly an area for, in particular in the context of trading, that we should be thinking about and in the context of ASEAN, Hong Kong, and the broader community.
Thank you, John. That's excellent introductions. I think we now all have a basic idea about what is ODR, and our next speakers, Mike, will tell us more about the benefit and the importance of the ODR for MSMEs. He will also show us some statistics. Mike was a representative to Untitled, and he's conducive to the conclusion of the ODR, technical looks on ODR by Untitled. I have also worked with him under APEC on the APEC collaborative framework for some years. I would say that he has his heart for ODR and his heart for MSMEs. So I'll pass the floor to Mike. Mike, please.
Good morning, everyone. Can you hear me?
Yes.
Thanks very much, James, for the introduction. And thanks to Secretary of Justice, Teresa Chang, for the invitation to speak. It's a privilege to be part of such a distinguished panel. Next slide, please. Next slide, please. I read recently that Apple was going to shift some of its production to Vietnam. Now imagine that you're an Apple supplier and Apple tells you that your product is defective and refuses to pay. You respectfully disagree, but despite your best efforts, you're unable to negotiate with Apple to resolve the matter. What options do you have? Litigation? You'd have to hire a lawyer and travel to California since Apple contracts will require litigation in California. In California courts, it takes on average 1.5 years to resolve a simple contract dispute with an MSME at a cost of nearly half the value of the claim. The cost of litigation can easily exceed the value of the dispute. And during the COVID-19 pandemic, court closures and travel restrictions would have made pursuit of a lawsuit impossible. Arbitration, you'd still have to hire a lawyer and travel to California, plus arbitrators charge up to $1,000 per hour for cases that take on average 11 to 16 months to resolve. After a year, you will have run out of money and the commercial relationship would be ruined anyway. The third option is not to challenge Apple. Over time, however, the problem will fester and cause serious friction. Lastly, you can look for a different client, but it's nearly impossible to find another buyer like Apple. None of these solutions we've looked at are good so far, especially for MSME suppliers. Fortunately, there may be another solution. It's called ODR. Next slide, please. As John mentioned, online dispute resolution has a wide definition and can include almost any dispute resolution process, including negotiation, mediation, facilitation, arbitration, or other adjudication, so long as it's carried out online. It's been defined as ADR enhanced by technology, but today, ODR is going beyond online ADR, making use of advanced facilitative technologies and adjudicative algorithms. We've only begun to tap into the potential of computer-led processes to resolve disputes. Next slide, please. Next slide, please. As Secretary for Justice Chang mentioned, UNCITRAL recognizes ODR as a vital way for resolving disputes by using technology as a facilitator to traditional methods such as negotiation, mediation, and arbitration. The UNCITRAL technical notes on ODR establish basic procedural recommendations or good practices for ODR. As the UNCITRAL technical notes recognize, ODR is designed to assist buyers and sellers in resolving disputes in a simple, fast, flexible, and secure manner without the need for physical presence at a meeting or hearing. For most e-commerce disputes, ODR is just not an alternative, it's the only practical redress option. The pandemic has greatly accelerated the use of ODR. UNCITRAL drew on the success of existing ODR platforms such as those developed by eBay and PayPal, with combined experience resolving 60 million disputes a year. Next slide, please. The use of technology enables parties to communicate without the intervention of a neutral person. It offers seamless navigation through a myriad of dispute resolution options. The ODR computer-led dispute resolution process reduces timelines and costs to keep them in proportion with the underlying value of the transaction. It offers participants the flexibility to engage in the process at the time and place that best suits their needs. Next slide, please. As the UNCITRAL ODR notes recognize, in order to offer ODR as a turnkey solution, a common technological platform must be established. It provides the framework that allows the parties to resolve the dispute electronically. All communications and ODR proceedings should take place via the ODR platform. The ODR platform and ODR administrator are responsible for process issues, including fairness, due process, transparency, neutral appointment or selection, and the performance capabilities of the ODR platform. The platform must be highly secure. Next slide, please. The UNCITRAL technical notes also provide for different stages of the dispute resolution process, including the use of negotiation, mediation, and a third stage, which may be arbitration. The various stages act as a funnel so that only a few cases need to escalate to an online arbitrator. Most disputes are resolved by negotiation or mediation. With ODR, the negotiation phase is managed entirely by software for speed, efficiency, and cost effectiveness. If no settlement can be found, the case may escalate to third-party resolution. The ODR provider selects the online neutral from a list of approved neutrals. The neutral provides online mediation and, if necessary, online arbitration. Next slide, please. As the General Assembly has recognized, the UNCITRAL ODR technical notes are based on the principles of fairness, due process, transparency, accountability, impartiality, independence, efficiency, and effectiveness. Next slide, please. The General Assembly has endorsed the UNCITRAL ODR technical notes, recommending that all states and other stakeholders use the technical notes in designing and implementing online dispute resolution systems for cross-border commercial transactions, and requesting all states to support the promotion and use of the technical notes. The resolution represents the views of all 193 members of the UN General Assembly. Next slide, please. Global e-commerce has been expanding rapidly, especially during the pandemic. UNCTAD reports that globally business-to-business e-commerce was worth nearly $21.8 trillion in 2019, while business-to-consumer e-commerce was worth $3.9 trillion. In the ASEAN region, e-commerce is also expanding rapidly with an average annual growth of 25%. That's over a 3-year period. The region is now projected to be the 4th largest economic bloc in the world by 2030. Next slide, please. The growth of e-commerce has been fueled by the spectacular increase in the number of individuals connected to the internet. The ASEAN region has 4 out of the top 18 internet economies in the world. Indonesia at number 4, Philippines at number 12, Vietnam at number 14, and Thailand at number 18. The region also leads the world in mobile phone internet use. Next slide, please. The internet has changed everything. It's lowered trade barriers and allows entrepreneurs to connect with customers across borders. Cross-border movement of goods has reached 40% of global gross domestic product. The internet provides MSMEs unprecedented access to those international markets. Next slide, please. Effective dispute resolution is essential to the continued growth of e-commerce, especially for MSMEs. An APEC Business Advisory Council survey of APEC businesses before the pandemic found that a lack of effective dispute resolution to be one of the greatest challenges faced by MSMEs in the digital economy when they trade across borders. 58% of respondents cited it as a major or severe problem. In emerging economies, that number rose to 74%. Next slide, please. It's worth noting that EU and UK studies have found the same thing. In the EU, 35% of cross-border disputes of EU MSMEs remain unresolved, with the average value of the dispute being some $50,000 US. The UK study found that 34% of MSMEs would have liked to have challenged the supplier because of unfair contract terms, but did not have the resources to do so. Again, these studies were before the pandemic. Next slide, please. The cost of unresolved disputes are much higher for MSMEs and can lead to failure and bankruptcy. The vast majority of business-to-business disputes are about payments, since most contracts use deferred payment terms. MSMEs are particularly vulnerable to late payments as cash flows and credit lines are far more restricted than for larger companies, and even more during the pandemic. Next slide, please. It's important to have a rapid way to resolve disputes, since disputes frustrate parties and damage relationships. Use of ODR can provide the means to maintain strong relations for partners in the supply chain. It also helps provide stability in the marketplace by creating a practical and realistic forum to ensure the rule of law. Next slide, please. Theoretically, these problems could be handled by the courts, but practically speaking, the courts don't work well for cross-border issues involving the global supply chain and MSMEs. They're too tied to geography, jurisdiction, and in-person enforcement, and cannot cope with cross-border low-value disputes. In fact, the courts already struggle to keep up with offline domestic case volumes. Here you see the numbers for the ASEAN countries from the World Bank Doing Business reports on enforcing contracts in 2020, before the pandemic. It took on average over 578 days to resolve a simple domestic commercial contract dispute involving an MSME at a cost of 43.4% of the value of the claim. Next slide, please. And here you see how the ASEAN countries stack up with other regions. It's on a par with those of the European Union and the OECD. Of course, during the pandemic, it was impossible to resolve disputes in courts due to court closures and restrictions on travel. Next slide, please. One recent survey found that 90% of respondents favored arbitration in cross-border trade. But according to multiple sources, including the World Bank, arbitration is too expensive and slow for e-commerce supply chain disputes. UNCITRAL recently developed expedited rules for arbitration, but the time limit for resolving disputes is still 6 months, and it's still expensive. As a friend of mine said, MSMEs couldn't afford the coffee at most arbitration centers. Next slide, please. APEC's the first region to implement the work of UNCITRAL on ODR. It created the Apec Odr Collaborative Framework, which draws from the UNCITRAL technical notes. Under the framework, APEC partners with ODR providers to offer ODR for business-to-business cross-border. Yoshi will give us more details on the Apec Odr Collaborative Framework. The EU Odr platform was implemented in February of 2016. It allows submission of complaints via an online form, which are then referred to a competent national ADR or ODR entity that provides online mediation and arbitration. Although vendors are not required to participate in ODR, many do, consumers can easily find EU ODR providers. The EU ODR platform has received over 111,000 claims since inception in 2016, and 45% of the claims involve cross-border transactions. Next slide, please. As the Secretary of Justice mentioned, the ASEAN region is also developing an ODR network for consumer disputes, and Mr. Keong will tell us more about that later today. Next slide, please. Here you see some of the ODR providers who have expressed interest in partnering with APEC under the collaborative framework, and you'll hear from two of those providers later today, Ibrahim and the Thai Arbitration Center. Next slide, please. There are also a number of ODR platform service providers that have been working with APEC and helping design and implement the collaborative framework. ADR providers can license the use of technology on a case-by-case basis from these ODR platform designers. They don't need to invest in or own the technology themselves. Next slide, please. Governments have a crucial role to play in promoting ODR to MSMEs and the legal community. Surveys show that microenterprises tend to work without clear contracts and dispute resolution clauses, which leave them vulnerable in case of a dispute. Widespread adoption of ODR would promote a culture of contract. In turn, it would make transactions more efficient, driving down risk and making MSMEs more competitive by lowering cost. ODR can bring economic advantages for everyone, reducing transaction costs for both buyers and sellers in the supply chain. Next slide, please. ASEAN governments have taken efforts to promote capacity building for MSMEs and implement ODR. And you see some of the efforts listed here. For example, Vietnam held training sessions and an ODR pilot with Vietnamese MSME business leaders. The ODR pilot utilized negotiation, mediation, and arbitration processes to resolve disputes, such as late delivery, payment, and quality issues. Next slide, please. Before the training, Vietnamese MSMEs were surveyed. They favored negotiation as the preferred means of resolving disputes, as you see on the slide. Arbitration and the courts were unpopular because they were too costly for MSMEs. Only 1/3 of the participants believed that ODR would be helpful in resolving their disputes. Next slide, please. After the training, there was a remarkable shift. The vast majority of the MSMEs believed ODR would be important to use in resolving their disputes. I'd like to thank Duong Nguyen from Vietnam for providing these two slides. He leads the work in Vietnam. It illustrates perfectly why capacity building is so important in implementing ODR. Next slide, please. As we have seen, ODR e-justice is an essential component of economic growth. ODR can help create markets for micro and small businesses where none currently exist. It will be of substantial benefit to the millions of small businesses and consumers in the ASEAN region who do not have access to effective dispute resolution remedies. ODR can be a cornerstone for the next justice system in the ASEAN region. Thank you very much, and I'm available for questions.
Thank you. Thank you very much, Mike. I think capacity building is indeed very important. In an APEC survey, those who responded saying that they do not want to use ODR because The reasons we asked them is because they said they do not know what is ODR and how to use ODR. And that's an important impediment for the use of ODR, in particular for MSMEs. That's why we have the workshop today, and also more capacity building work is needed to tell people how to use ODR and the value of ODR. Mike has indeed made a very strong case on the importance and value of ODR, in particular for the MSMEs and for the ASEAN traders. He also mentions about some development under Untitled on ODR. And our next speakers, Yoshi, will speak more about the international developments under Untitled, under APEC, and other relevant international developments. Yoshi I have been working together for some years under APEC as well. He's currently the convener of the APEC Economic Committee, friends of the chair on strengthening economic legal infrastructure. So I will pass the floor to Yoshi. Yoshi, please.
Hello, James. Can you hear me?
Yeah.
Okay, so thank you very much for serving as a speaker in this session. And I'd like to explain the much more details of the online dispute resolution international rule-making project in UNCITRAL and APEC and ISO. And what is the discussing point in substance? That is my presentation, perhaps. And in this order. So the ODR has been used in various fields as an efficient tool for the dispute resolution in the United States.
唔好意思，我唔係好。
And has encouraged the use of ODR in the territory. And even in Japan, ODR has become an important issue to be discussed in the government and the Japan Federation of Bar Association since 2019. So online shopping can easily become cross-border transactions, and cross-border disputes can easily happen. And the effort for making international rules on ODR has started for two purposes. First one is the effective reaction to the cross-border e-commerce disputes. Excuse me. And secondly, facilitating the use of ODR even in the emerging market economies. So that for these purposes, some international organization try to make a kind of the international rules or for the harmonization and capacity buildings. And as Mike mentioned, or Teresa mentioned, so that we had an UNCITRAL ODR working group from 2010 to 2016. Mike served as the head of the delegation from United States, and I served as the head of delegation from Japan. And at the very beginning stage, United Nations ODR uniform rules for B2B and B2C were tried to establish. And as Mike mentioned, we have a three-step approach. And the first, negotiation or complaint handling. And secondly, the neutral appear and the mediation process starts. And it fails, we are moving to arbitration. So all processes will be basically conducted by online-based document. So that is a basic concept. And thirdly, and we try to make a simple and quick process for low-value disputes. At the very beginning stage, UN online arbitration rules were tried to establish, and under the concept, a single arbitrator chosen by the ODR administrator, because we have to quickly issue a decision. So the parties' right to choose arbitrator is removed. And we try to establish a system for the all awards shall or should be in public on website, except the private information, because we need to collect big data for example, future use of AI for this kind of the quick and simple and easy and efficient dispute resolutions. And additionally, the enforcement should be much more efficiently conducted. And from this viewpoint, the trust mark system or similar concept is needed for the substantial enforcement. And finally, we tried to establish worldwide uniform rules for the merit, for example, CISG or the UNIDROIT principle. And that is the first concept. And at the very beginning stage, the discussion is very fruitful, and we believed at the time, so we could establish the brand new perfect rules very immediately. But gradually, a serious issue appeared. The problem is the treatment of the validity of the arbitration agreement, between the consumer and the business corporation. So there are two different policies worldwide, and these policies conflict each other. And the United States and other countries, of course, it should be valid or have to be valid. But EU, Japan, and other countries, consumer has a cancel right, should have a cancel right about the arbitration agreement for the pre-dispute arbitration agreement between the consumer and the business corporation, B2C. And so it was deeply influenced by the appearance of the regulation in EU. Since a consumer should not be removed its right to go to court, the consumer shall have a right to cancel the pre-dispute arbitration agreement. That is the basic concept of the ADR Directive 2013 EU and ODR Regulation EU. So since then, since 2013, the discussion was becoming very tough, and so the almost, we are stuck. And finally, we established ancestral technical note on ODR. So this is a very good, the principle for the future direction of ODR. But one problem is it clearly said we have it's a document itself does not have a legal effect. And additionally, so this technical note recommends three-step approach, but no explanation about the third step, because there are two different interpretations about the third step. So the one is binding arbitration, but another one is the other one is a non-binding arbitration for recommendation, which does not have any legally binding effect. In other words, res judicata. So the EU is now establishing its own ODR platform, but the ancestral project was substantially terminated by that conflict or the disputes. So it means, the other countries except EU still need uniform rules and schemes for the global ODR platform with negotiation and the third parties interventions. So we tried to find another place to discuss this kind of the uniform rule and schemes. And APEC was chosen, and APEC started its project to establish another global ODR platform. And Ancestral and UNIDROIT assist the APEC project on ODR. So B2C issues were avoided in the stage, at least at the very beginning stage, because if we try to stick to the B2C issues, we have to resolve so many issues, because there are differences or barriers of the policies of the consumer treatment, especially for the dispute resolutions. So the formal proposal was made in Vietnam 2017, and since then, every year we have a workshop or meetings, and in Papua New Guinea, and Japan, and Chile, and Malaysia, and now we, due to the COVID-19, we did it online. And APEC will not work as a provider of the ODR platform, of course. And in this project, instead, APEC will encourage members to collaborate for the wide use of ODR and provide model procedure rules and encourage many ODR providers to join the APEC collaborative framework on ODR. So now a document of APEC collaborative framework on ODR and APEC model procedure rules on ODR has been already approved. And it is a substantially same as the final draft on model procedure rules on UNCITRAL. So UNCITRAL could not finally issue, but APEC instead issued the substance. So APEC collaborative framework on ODR aims to assist member economies to encourage the use of ODR and potential business cooperation users in the APEC region, including e-commerce market provider, to actively use ODR. And academic institutions in the APEC region assisted to maintain a web page on the satellite website of APEC, where the list of ODR service providers adapting APEC model procedure rules on ODR is presented. So this is the future work, and so we have already finished the series of the webinars on APEC ODR and online, and we discussed, the several very critical topics from August 2021 to October 2021 by the 4 series of seminars. And we will have another big ODR workshop. And I said online, but because of the improvement of the COVID-19 situation, the workshop will be physically held in Tokyo, February 2022. And please come to Japan and join this workshop. And finally, I'd like to introduce another project in ISO, International Organization for Standardization, and about the ODR. Now, one project, which is called TC321, has started in ISO as below. So this is a standardization in the field of transaction assurance in e-commerce related to upstream, downstream processes, including the following: including the protection of online consumer rights, including both prevention of online dispute and the resolution process. So it was proposed by China, thanks to China and Hong Kong, China. And in this project, Japan tried to use this ISO standards as a trust mark for the implementation of arbitral awards or recommendations issued in the scheme of ODR. So I have already explained about the concept of the UNCITRAL at the very beginning stage. But we have now chance to make a kind of the trust mark for the ISO for the ODR by the ISO standards. So now the presentation from Japan was made in 2019, and we have several meetings for the discussion. And finally, tomorrow, I will make a presentation about this project, and voting will be made hopefully in this month. And so this is the stage of the ISO project, and now we are try to get a preliminary work item for the ODR, and we try to establish new ISO standards within 3 years. So of course, discussion in UNCITRAL and the discussion APEC will be included. And of course, this is not limited in Asia Pacific area, but also for the worldwide. So we try to consider the voices from Europe and other countries, and we try to establish ISO new standards for ODR. So these are the present international rule-making efforts. And thank you very much, James. This is the end of my presentation. Thank you.
Thank you very much, Yoshi. Thanks for taking us for an overview of various international and regional developments. In fact, there are still a number of issues on ODR, in particular under international developments of ODR, that need to be resolved. That's why, as our Secretary Jen said at the opening, we have launched the IKIP on ODR, which will study these various issues in collaboration with UNCITRAL. We are running out of time, but I think that we can take one or two questions. I've received some questions. So the first question is, ASEAN member states have different levels of technological development. Is it feasible to have ODR to resolve cross-border disputes between traders in different ASEAN countries? I will ask each of our panelists to briefly respond. John?
Sure. Why don't I start then? Thanks very much, James. I think it is very much feasible for the simple reason that the hardware that you need for ODR resolution is very simple. As we discussed, it could be the mobile phone, which is widely used throughout ASEAN regardless of the jurisdiction. And similarly, the entire system is designed to be simple, such that there is no significant benefit as between jurisdictions. It's not a process where you need to hire lawyers of different levels of sophistication to try to present your case, but really these are ultimately disputes that will be heavily factual. For example, if it's an issue over a defective product, it's a matter of taking a photograph of the defective product and then having the some kind of negotiation or mediator to help facilitate in the resolution. So I think it is actually, as I mentioned in my presentation, a situation where the barriers to entry are lowered such that ODR does allow for relatively even playing field across different jurisdictions in ASEAN, even if they're at different levels of development.
Thank you. Mike, you want to respond?
Sure. Yes, I agree with what John has said. During my presentation, I noted that 4 out of the top 18 countries in the world are ASEAN countries as far as connection to the internet is concerned. It's had connection to the internet has had an incredibly high growth rate within ASEAN countries. It's the #1 country in the world as far as mobile phone use. 90% of individuals in ASEAN countries connect to the internet via mobile phones. I charted out the numbers as far as ASEAN economies were concerned, and I think there were 2 countries that had 50% connection levels as far as access to the internet is concerned, and all the others were substantially higher. So I think at 50%, that's sufficient as far as implementing ODR is concerned, and also we're seeing incredibly rapid increase as far as the number of individuals connected. So I don't see technology as being an issue as far as the ASEAN countries are concerned. I think capacity building is more of an issue, but not the number of individuals connected to the internet. Thanks.
Thank you, Mike. And Yoshi?
Thank you very much. And we'd like to provide the users in the emerging market economy countries, by our efforts for the capacity buildings. And so they do not have to worry about how they establish the rules and the manuals and something like that. So ISO will, for example, provide basic principle and the technical manuals, technical conditions, and the operational manuals. So that they can be used free and very easy. And additionally, as Mike explained, that there are so many, now the ODR system providers. And so that they are competing each other, and that they will provide a very reasonable ODR systems. And so the parties in the emerging market, even parties in the emerging market can easily use such a, or can easily choose the one of the such a system vendor and try to establish their own service with the international rules which will be provided substantially United Nations and APEC or ISO. So that is my answer. Thank you.
Thank you, Yoshi. So I think the answer is clearly yes. As long as for the users, if you have a mobile phone, basically you can do ODR. While we leave all the technical details to the ODR service providers, they can take care of the technical aspect. So I think that is very useful information. I'm afraid that we are running out of time because we still have 2 more sessions to come. Now we have an overview of ODR and how and why it's important for the business, in particular MSMEs, for the ASEAN trade. We'll then hear from some businesses from the business perspective, as well as some ODR providers at the last sessions. So could you join me to give a big round of applause to all our distinguished speakers?
Thank you very much, Dr. Ding, Mr. Chun, Mr. Dennis, and Professor Yoshihisa. Please remain on stage for a quick virtual photo taking. Our cameraman right there, straight ahead, and also our online speakers. You can take a look at your camera on your computer. And our cameraman right there with the blue mask. Okay, smile. 1, 2, 3. Thank you very much, everyone. Thank you. Please be seated. Oh, one more photo. Okay, 1, 2, 3. Thank you so much. Please give them another round of applause. Thank you for the time, and your information is very useful. And now here comes to our second panel discussion on challenges traders, including MSMEs, face in cross-border dispute resolution and how ODR can help them. We are pleased to have Mr. Francis Ho, JP, as our moderator, and attorney Irene D.T. Alagog, Professor Bien Yong Min, and Mr. David Dobwell, BBS, as speakers. Mr. Ho is the Deputy Director General of Trade and Industry Department, Hong Kong SAR Government. Mr. Ho, may I now pass the floor to you? Thank you.
Good morning, everyone, and welcome to the second panel session of this morning's workshop on ODR. It is indeed my great pleasure today to discuss with other distinguished panelists on the challenges faced by traders, including MSMEs in cross-border dispute resolution, and how the ODR can help in this respect. Before we start, allow me to make a very brief 30-second commercial. The ASEAN-Hong Kong-China Free Trade Agreement entered into force in full for all parties since February this year. Under this FTA, Hong Kong-China, in collaboration with ASEAN member states, has committed to advance an economic and technical cooperation, or ECOTEC in short, work program in the form of capacity building and technical assistance projects. Today's workshop is indeed one of the very first batch of projects implemented under the ECOTEC work program commenced earlier this year. I sincerely hope that the fruitful outcome of today's workshop will extend across boundaries to our ASEAN friends, although they cannot join us here in Hong Kong physically. But next phase, I hope we can all see you in Hong Kong. Turning to the topic of this session, in the next 50 minutes or so, our panelists will introduce the challenges of cross-border disputes to traders and the value of ODR in this respect. No doubt that we are all witnessing the economic disruption brought about by the COVID-19 pandemic. And unfortunately, it has triggered off indeed more cross-border trade disputes. We are pleased to have 3 distinguished panelists to share their experience with us today. After their presentation, we will then move on to a very short Q&A sessions. And I will encourage participants who are not joining us here using the chat box function. For those in this room, welcome to make use of the question slip. So without further ado, I would like to introduce our very first speaker in this panel session, Mr. David Dobwell, who is joining us here in Hong Kong Live. He is the CEO of Strategic Access Limited and the Executive Director of the Hong Kong Apec Trade Policy Group. As a veteran journalist and an expert on international business, global trade, and economic developments, he has been closely engaged with APEC's ODR initiatives since 2017 and contributed business inputs through various means, including the APEC Business Advisory Council. David will speak on how ODR can give MSMEs safe access to global markets. David, your floor is yours.
Thank you, Francis, and welcome to all of you. I look forward to the opportunity for us to be working fully physically with the 400 or so participants that we actually have here, rather than the 100 of you here today. Still impressive to get so many together, I believe. I sit here sort of as an interloper because I'm not a legal expert. I'm not a lawyer. And I have become aware of and involved intensively in ODR really because of the work I've done in ABAC, supporting our APEC Business Advisory Council members, and the concerns we have over our SMEs in the APEC region. Important, first of all, to be clear what we're talking about with SMEs, because across the region there's a lot of disagreement or failure to be clear about what an SME is. If you're in Korea, for example, an SME starts at 500 people, and almost all of the SMEs they talk about are manufacturers. If you talk about Hong Kong, then you're talking about companies that are smaller than 10 people, and you're largely talking about services. So the concept of SME is blurred. From my point of view, the concept is useful because of a number of criteria. And that's basically because there is an institutional weakness associated with an SME that you don't see in a large company. You will, sorry, we haven't flipped on to the second slide. An SME will not have a dedicated accounts department. It will not have a dedicated IT department. It will not have a legal department. Essentially, the CEO will be the jack of all trades who manages all of the generalized concerns that face the company. That includes the management of a dispute if it arises. In the absence of that institutional maturity, small companies have particularly acute problems and particular vulnerabilities once they go into overseas markets. Next slide, please. The reason why I became concerned about this as a particular issue within ABEC arose as we began to do intensive work, largely driven by attention being paid to ODR in APEC itself. Because of APEC's or APEC Business Advisory Council's concerns about small and medium companies, and the initial institutional weaknesses I talked about in part explain that. Next slide, please. It was for the last decade, the APEC Business Advisory Council members have been driving very hard for small companies to play a larger part in international business. And there was a sort of dawning realization in 2015, 16, 17, that there was a danger that we could be accused of acting in bad faith, i.e., we were encouraging small companies to go overseas, but we were not adequately preparing them for the experiences they were going to face. I flippantly have commented in the past that it's like we're sending business people, small companies, out of the trenches in warfare with baguettes in their hands, not with firearms, and that leaves them extremely vulnerable. We had a very interesting piece of research from the University of Victoria in New Zealand, in Wellington, which audited SMEs doing international business in New Zealand. 64% of the companies responding to the work in this study, 64% did not even have a proper contract. It's not a matter of a dispute settlement clause in a contract. They just didn't have a contract. They were coming to fairs like we hold here in the convention center. They were meeting people, they were exchanging cards, and business was then being done on the basis of a card exchanged. The vulnerability linked with that, if you think about it, is quite extraordinary. They were absolutely ignorant beyond that of the scale of dangers they faced and of the fact that under present non-ODR circumstances, the cost of settling any dispute would have been impossible for them, nor would it be quick to deal with. I've got the next slide up already. We discovered a lot of really interesting numbers, many of them provided by Mike Dennis, who you heard earlier, who's been a marvelous source of statistical information on this. But small businesses, the APEC Business Advisory Council in general, did not have any awareness of the scale of the problems that we're dealing with. 820 million cross-border e-commerce disputes in the reported from the European Union. The fact that 1 in 20 cross-border contracts statistically end in a dispute, 5%. That each dispute was not on average, between you and a counterparty, but because of the complexity of supply chains nowadays, averaged 6 companies. So if you got in a dispute, you are not just in dispute with one partner, you were in dispute with 6 and had to conduct 6 legal actions simultaneously. Completely ignorant of that reality. Mike mentioned previously, the average sum in dispute tended to be, was around $50,000 US. And the average dispute lasted 15 months. Now, if you took an average lawyer charging you $1,000 US an hour, you can imagine that over a 15-month period, the sums involved in the millions, not in the thousands. And so very quickly, an SME faced with these circumstances realizes that the cost of settling a dispute is going to be immeasurably higher than the sum actually in dispute. As a result, you don't resolve the dispute. You walk away, you take the pain. If it costs your company its business, then it costs your company its business. Either way, there is no practical resort to settlement. Next slide, please. So we realized that ODR could make a really radical difference to the efficacy with which small companies could go abroad. We began to recognize that SMEs were in effect not protected currently, and that absent online dispute resolution, that would not change. What we liked in particular about the ODR processes was the preference to focus on dispute avoidance in the first place, educate on how disputes can arise and look for warning signs, focus on negotiation, then mediation, rather than consider litigation, which in practical terms is not acceptable. We still hope for, though I don't believe we've yet properly developed, we hope for a castle on the hill moment in the future when disputes could be dealt with almost entirely by algorithms and AI. In blunt terms, the reason why cases are not, in practical terms, resolvable is because lawyers cost too much. And so the less human involvement, inevitably costly, the lesser human involvement, the better. So ultimate solutions come from increasing use of AI to provide us with what we would call early case assessments. That is, looking at case material across the world using AI and algorithms, giving you an indication. 80% of for example, 80% of the cases brought worldwide on this issue have failed. Therefore, we suggest the odds that you will succeed are not high. Those early indications for an SME are very valuable in hinting whether you should, in practical terms, proceed or not. Next slide, please. Hong Kong has been a leader in this, and there are a number of other economies that have worked hard, but the work that James's department James's team has done in APEC and elsewhere has been terrifically valuable in coordinating the APEC work. As part of that, establishing Ibrahim, which we're going to hear more about in the next session, is very valuable. And is valuable not just in terms of the cross-border dispute potential. Very interestingly, in the middle of last year, Ibrahim created a COVID ODR scheme, which was accessible to local companies for local disputes rather than cross-border disputes. That had the specific aim of helping companies to manage disputes that were going to inevitably arise out of the pandemic recession. And a recognition that an awful lot of perfectly viable companies were going to be involved in disputes regardless of any culpability. Most would not be have been culpable of any sin. So the Ibrahim product to offer ODR services to companies that have got into disputes because of the pandemic recession, we believe would be very valuable. Very important that there was no assumption of guilt, that there was no, you avoid a potential stigma linked with a bankruptcy, and it would allow companies to recover quickly out of the pandemic, or much more quickly than would have been the case if you had to deal with disputes through normal litigated processes. Next slide, please. So even though there's been huge progress and we've got active work going on, from a business point of view, we still have problems. Most of the presentations I've been involved with over the past 18 months have had audiences really packed with hundreds of lawyers, which is marvelous because they're going to be driving this process. But really astonishing how few business people arrive in the audiences. And it's been, at points, quite depressing that how uneducated and in some circumstances uninterested businesses were to learn about the potential of ODR to solve disputes that might arise. So I see a still urgent need to broaden education across the business community. And for the chambers here and across the ASEAN region to take ownership of the ODR process. I've had presentations at the General Chamber, the British Chamber, planning for the American Chamber, the important thing there has been when I first went to the General Chamber said, "Oh, we should arrange this under the legal committee." Again, I said, "Please no, the legal committee is full of lawyers. I don't want for us to, within the General Chamber, to talk to members of the legal committee. We need the SME committee involved." And so actually, helpfully, the General Chamber did that. And it has helped the General Chamber to take ownership of the ODR problems. This can be emulated across the APEC region, the ASEAN region, it's very important that it does so. We need more of our member economies to be members of the framework. And obviously, there's a very important role that I think APEC and the APEC Business Advisory Council still have going forward. So finally, to the last slide, to summarize, I still believe there's a massive effort needed in educating business. Still many steps to be made. This initiative needs to be led not only by lawyers, but by business people. And that we need to be talking to the SME committees of business organizations, not to the legal committees, whether we're here or in any economy across the region. We need to see more economies adopt schemes under the ODR framework. And we need our members to, having had to use ODR services, to become advocates for the further use or further development of ODR. We do need more case experience. We need the lawyers to be providing the practical details which help business people to realize just how serious and practical the problems are that they're going to be facing here. I'm confident, given the work that's been done, that was outlined earlier by Mike in particular, I'm confident that the APEC forum remains an extremely valuable forum for moving things forward. And so I look forward to further activity, both within APEC and with the APEC Business Advisory Council.
So thank you very much, David, for the presentation. I think one of the key message that we can get is that promoting the adoption of ODR to MSMEs is not really only confined to the work of the legal community. It requires the work of also the business community, government, as well as academia. I hope we will have more time to discuss on this. So let me now introduce our next panelist, Attorney Irene Alogo. She is the Executive Director from the Office of Alternative Dispute Resolution in the Department of Justice of the Philippines. She is also a law professor covering topics in ADR. Prior to her appointment to her present position in the Department of Justice, Attorney Irene has over 10 years of extensive law practice and has held key positions in the Philippine government, including the Department of Agriculture, the Judicial and Bar Council, as well as the House of Representatives Electoral Tribunal. Attorney Irene is a trained arbitrator of the Philippine Dispute Resolution Center. She also represents the Philippines as one of the delegates to the UN UNCITRAL working groups. She will share with us the benefits of online dispute resolution for ASEAN traders, as well as the Philippines' experience in promoting ODR. So, Attorney Irene, the floor is yours.
To all the delegates in this virtual conference, I wish you a pleasant day. I am privileged to be invited to speak in this event regarding the current issues confronting Philippine micro, small and medium-sized enterprises, or MSMEs, in cross-border trade disputes. Next slide, please. While majority of challenges encountered by Philippine MSMEs are distinctive in certain aspects, they share parallels with those faced by traders in adjacent countries. First, there is an inherent risk of conflict between foreign suppliers and local purchasers because of communication barriers and cultural differences. These factors contribute to hesitations over establishing or expanding cross-border trade networks, impeding transaction growth. Second, there is a pervasive fear of lawsuits among Philippine traders. Litigation is thought to be prohibitively expensive and complicated. Litigating business disputes across borders, on the other hand, presents even greater jurisdictional, evidentiary, and enforcement challenges. Most MSMEs tend to dread these challenges due to limited resources. Third, alternative dispute resolution and online dispute resolution are still in the early stages of development and are only beginning to gain traction here in the Philippines. Despite their practical utility, ADR and ODR remain unfamiliar to local traders. Simply said, MSMEs' trust and confidence are being cultivated concurrently with the establishment of the systems that are essential to catalyze the widespread use of ADR and ODR in the country. Lastly, there are geographical constraints in terms of ICT infrastructure, connection, and capacity that must be addressed. Because of the country's archipelagic landscape, ICT capabilities in the Philippines are concentrated in the urban areas, and the country's most remote areas continue to face challenges that place most MSMEs at a competitive disadvantage when attempting to gain access to ODR. Next slide, please. The establishment of the ASEAN Economic Community in 2015 strengthened the financial integration within the Southeast Asian region, since it opened the doors for cross-border transactions. However, with the opening of cross-border offerings came cross-border transaction disputes that were not handled uniformly across the region. As such, cross-border cooperation between and among the member states must be reinforced in order to address multi-jurisdictional financial consumer disputes. Likewise, affordable redress mechanisms must be made accessible in order to increase consumer confidence to keep up with economic growth within the ASEAN region. Hence, as a commitment under the ASEAN Committee on Consumer Protection, the aim of the Philippine government when it established the National Online ADR is to provide an online platform that can be accessed by citizens of member states to strengthen cross-border cooperation as well as facilitate consumer access to redress multi-jurisdictional disputes. Next slide, please. To a certain extent, cross-border ODR systems can address said challenges. First, this can serve as an accessible, expedient, and expensive settlement mechanism that can avert further cross-border trade disputes or claims. Second, available and readily accessible third-party ODR mechanisms may reduce international trade risk, uncertainty, and cost for Philippine traders and companies. If ODR systems or services within the country have streamlined design and procedures in accordance with globally accepted standards, Philippine traders and companies can easily access and avail cross-border ODR services even with their limited connectivity and resources. Presently, there is only one cross-border redress mechanism under the E-Commerce Act or Republic Act number 8792, where an aggrieved party can file a consumer complaint before the Philippine Trade and Consular Office or Embassy or directly against the foreign government agency or regulator of the country where the respondent retailer, reseller, distributor, or manufacturer is located. Next slide, please. In the Philippines, alternative dispute resolution is being actively promoted by the government as a means of resolving conflicts. In the pursuit of delivering speedy and impartial justice, Republic Act Number 9285, or the Alternative Dispute Resolution Act of 2004, was enacted by the Philippine Congress. This law created the Office for Alternative Dispute Resolution as an attached agency of the Department of Justice to primarily promote the use of ADR in the public and private sectors. It acts as the lead government agency in monitoring, studying, evaluating the use of ADR by the public and private sector, in recommending needful statutory changes to develop, strengthen, and improve ADR practices in accordance with world standards. The OADR conducts trainings, orientation activities, advocacy programs, accreditation and certification of practitioners, and reviews and proposes policy issuances and implementation relevant to ADR. The OADR is tasked to evaluate and monitor challenges encountered in the practice of ADR and address it at the policy, regulation, and legislative level. Next slide, please. Towards this policy, the OADR, for its part, included in its strategic direction aspects of consumer protection and business disputes. As part of our office's operational plan, we continue to work on improving governance and economic justice by supporting ADR mechanisms, especially relating to consumer protection, including e-commerce and business disputes. Furthermore, among the policy agenda of the OADR is to support and liaise in lobbying for legislative measures on ADR for e-commerce and online ADR. Next slide, please. The Online Dispute Resolution Mechanism under the proposed Internet Transactions Act is the country's answer to our ASEAN commitment to offer consumers a quick, inexpensive, and effective way of remedy without the burden and expense of taking formal legal action. This act aims to establish the Philippine Online Dispute Resolution System that will enable the country to act as the neutral third party between consumers and businesses that involve e-commerce transaction disputes. The Philippine ODR system envisions the linked government agencies that have a consumer protection function into one integrative system, which allows consumers to file a complaint against an entity in the Philippines wherever they are in the world. Cases filed through this system is usually resolved via mediation. When the PODRS is implemented under this law, it is envisioned to be an automated complaints handling system under the Department of Trade and Industry that handles the whole dispute resolution process from filing of the complaint up to resolution via mediation. Next slide, please. In line with the OADR's mandate, the agency supports the use of domestic and cross-border ODR. In the past year, the OADR has coordinated, supported, and provided relevant guidance for ODR initiatives of concerned government agencies and private ADR providers. Included in our advocacy activities is the information dissemination of the Philippine Online Dispute Resolution System in coordination with the Department of Trade and Industry and the use of ADR by the micro, small, and medium enterprises. This coming December, our National ADR Convention will focus on the synergy of traditional ADR and technology highlighting ODR, including international and domestic practices, initiatives, directions, perspectives, and recommendations. Next slide, please. Second, we advocate for the adoption of ODR, including support or recommendations for relevant legislation and programs. Right now, there is a bill in Congress for internet transactions, which includes the establishment of a national ODR system. Our counterparts in the Department of Trade and Industry also have an ongoing initiative to develop and operationalize an integrated ODR system for consumer protection. Next slide, please. Third, we continually participate in local and international initiatives, including the APEC and other fora, towards the adoption and use of ODR systems and services in accordance with global standards and best practices. Lastly, the OADR is ready to provide competency training and certification for ADR providers and practitioners for ODR services that will be established and used in the country. Next slide, please. With this thrust towards the promotion of ADR, we highly encourage ASEAN member states and our other foreign counterparts to support the use of ADR in cross-border dispute resolution systems to have a more uniform and innovative way of handling cross-border disputes. Next is to support the strategic direction of ASEAN in establishing a national online alternative dispute resolution system to promote the use of dispute resolution mechanisms in dealing with cross-border transactions. Lastly, it is without saying that cross-border cooperation is ensuring that member states of the economic region has aligned goals to have efficient and functional ASEAN dispute resolution mechanisms that will further increase the confidence of both consumers and businesses in transacting with ASEAN member states. Next slide, please. Oh, I think this is the last slide. Again, thank you for inviting me here today. Thank you.
And we are very glad to hear Philippines' experience in promoting ODR, and I'm sure we wish you all every success in the upcoming National ADR Convention to be held next month. So may I now welcome our third and the last panelist, Professor Bian Yongmin. Professor Bian is the Professor and Deputy Dean of the Law School of the University of International Business and Economics, a member of the Chinese Society of International Law, as well as a panelist of ODR Center of China International Economic and Trade Arbitration Commission. Professor Bian's research areas covers public international law, international trade law, dispute resolution, as well as arbitration law. Professor Bian is going to take us through the advantages of ODR and how we should introduce this useful platform to MSMEs. Professor Bian, the floor is yours.
Thank you very much. I'm glad to be here to share my points and Chinese practice in promoting ODR. And next page, please. So I think to help the MSEs to benefit from ODR, we need to let them understand what timely, cost-effective, and convenient dispute resolution means under the ODR. For example, our goal is to provide dispute resolution at affordable fees. And what affordable fees means, and to be frankly, we are not 100% clear at this moment. I checked the fees, the arbitration fees required by different arbitration institutions in mainland China, Hong Kong, Singapore, and the United States. I found that the fees vary from one arbitration institution to another. For the highest fee required by some institution are almost twice more than the lowest fee required by other arbitration institution. Of course, there are gaps in the lawyer's fees and the logistic fees too. But it's no doubt that the ODR will be much cheaper or inexpensive compared to the traditional dispute resolution. I don't think I will go through all this merits of ODR one by one, because the merits of ODR has already been explained thoroughly in the previous panel. So I want to share more about how China introduced ODR to the MSEs and what the lessons and experience we have for the other economies. So next page, please. I think according to many panelists today, the ODR are very good and ideal for MSEs to settle their disputes. But who like to be the first ones to try the ODR? How we convince the MSEs to adopt the ODR? Since we have, China already have reached ODR practice. In our domestic practice, we have already several thousands of cases settled by ODR, although most of them are domestic cases, but some of them are international. So we do have some experience in introducing ODR to MSEs. First, we found if we start with the parties who once came to ODR provider for dispute settlement, that will be most efficient or the best way according to our experience. Because those are the MSEs which already had a problem, had a dispute, and they need help. And of course, traditionally they use mediation and arbitration. Now the ODR provider got the chance to persuade them to try this online dispute resolution. For the time being, people are constrained by this pandemic. International travel is very difficult. Even the domestic travel sometimes is not that easy. So the parties are more likely to accept ODR for as an alternative. So we have several. We have some cases that the MSEs accept ODR because when they come, we persuade them. We got a chance to introduce ODR to them. And the second way we think is through the lawyers and the mediators. Because the lawyers and the mediators quite often help their clients in dispute settlement. If we educate the lawyers and the mediators, help them convince or accept ODR as an alternative way to settle the disputes, and they are going to persuade their clients to accept this new approach, because the clients, they trust their lawyers better than the other stakeholders. So the lawyers' advices are very important for MSEs. The last one I did not put on the PPT slides. The last way to introduce ODR to MSEs is through the e-commerce platform. For example, I visit Alibaba last month, and we learned on the Alibaba's platform, there are business-to-business transaction. So the Alibaba used the big data to assess who are the MSEs have better credits for those MSEs who always positively settle disputes with their trading partners. They always friendly in dispute settlement. The Alibaba will give them high credit and will give them financial guarantee for the future dispute settlements. So the other business will, from the e-commerce platform of Alibaba, will see who are the MSEs have better credits in their business and also in dispute settlements. If the business get the guarantee, finally trapped in a dispute, the Alibaba may pay the compensation within the guarantee. For example, 1 million renminbi first, in advance, before the final decision is reached. Of course, this is Alibaba's B2B dispute resolution now, but there is a possibility to persuade Alibaba to adopt this ODR in their platform. I think that is a powerful instrument to promote ODR. And when we convince and try to introduce ODR to MSEs, and what are the useful practical method or experience, and first we think the case-by-case introduction are most convincing. Of course, it's slow. I mean, when a party comes and you got a chance to introduce ODR to them face by face, and also describe all the procedure rules to them to make them fully understand how the case is going to be done, proceed in the future. And of course, we can have a workshop, and we can have the other online introduction through the website of the ODR provider. And here I want to point out that the MSEs, which are the entities that pay the cost of the ODR, and they are also the bearer of all the results of the dispute settlement. So their opinion, in our experience, is most convincing, is more convincing than me, and than my opinion. I'm just a scholar. So if we use the role model of some MSE, which already adopt ODR to solve their disputes successfully, to persuade the other MSEs. Their experience sharing, we found is very convincing. And the ice-breaking practice of ODR in the early stage are very important for all stakeholders interested in ODR. With that, ODR providers get confidence to advertise the ODR online, while their website. The introduction from ODR providers will provide professional help for MSEs to determine the use of ODR. So after we got 1,000 or several thousand or even 100 successful case of ODR, we are able to expand the experience to very broad area. Next slide, please. Okay, the challenges and experience. To our experience, it takes time for MSCs to accept, but the pandemic accelerates the acceptance of ODR among the MSEs. And different ODR providers provide ODR in a slightly different way. For example, the fee they charge are a bit different, and the details of the procedure also vary a bit. So there is a chance for this so-called forum shopping. The MSCs will look at different ODR providers and also examine their procedures and to choose the best one. And of course, they will also choose the forum to see, for example, whether the service will be provided in a certain language that is best convenient, most convenient. So there are some other experience and challenges, and the organizer reminded me my time run out, and I think I will close my presentation now. Thank you very much.
Thank you very much, Professor Bian. We have received indeed quite a number of good questions from the audience, but due to time constraint, I think we can only take one. This is the question that asks our panelists, what would you think would be the new skills required for owners as well as employees of MSMEs in order to compete in the digital economy, and especially in the adoption of ODR? May I start with David?
I think it's very difficult at this point to be specific about the skills they need. I mean, the lesson we are all having to learn, and old timers like me are having greater difficulty than youngsters, is that really all of the services, all the processes that historically we've managed on a paper-based understanding and are now being managed online. As people like Mike have mentioned earlier, on the hand phone, on the mobile phone, as well as on computers. So we are facing a future where pretty much everything we're doing will be managed electronically. There are great advantages that will come from that, and we have to internalize those competencies. So it's really just digital competencies, I think.
Yeah. And any comments from Irene and on Professor Bian? Irene?
Yes, just like what we are teaching here in the Philippines, of course, aside from the mediation skills that they should have process management skills in conducting the mediations, and also people skills, because we really need that here. And we're very glad that two of our major online sellers here in the Philippines has already adopted this online dispute resolution. And during our last convention in December 2020, one of them was able to present their online dispute resolution. And that is what we are trying to educate our other businesses here, especially the MSMEs. Thank you.
Thank you. Professor Bian, any comments?
So no comments, thank you.
Thank you very much. I mean, it's a very useful and fruitful session. So I hope you have also get as much takeaways as I do. I think one of the most important thing is ODR is really a collaboration, not only an initiative of the legal sector, but it requires the support of business community, academia, as well as government. And it is an initiative that has to be collaborated across the region through APEC or APEC and other different forums. So thank you very much for attending the session, and I hope you enjoyed it, and wish you all a very pleasant day. Thank you very much.
Thank you very much. Please remain on stage, and we'd like to take some time for the photo. And our online speakers as well, please look into the camera on your computer. On a count of 3. 3, 2, 1. Cheers. Thank you very much once again. It's a very insightful discussion. Thank you, Mr. Ho, attorney. Oh, one more photo. Okay, count of 3 again. 3, 2, 1. Thank you very much. Thank you, Mr. Ho, attorney Elo Gog, Professor Bien, and Mr. Dobwell. Thank you very much. And here comes our third and final panel session on experience sharing and use of ODR, opportunities and challenges. We are delighted to have Professor Yun Zhao as our moderator, and Dr. Nadia Alexander, Ms. Pachleda Pumprasad, and Ms. Pui Ki Emmanuel Ta as speakers. Professor Zhao is the head of Department of Law at the University of Hague Conference on Private International Law. Professor Zhao, the floor is yours. Thank you very much.
Good afternoon, ladies and gentlemen. I'm very pleased to chair this session on of the ODR workshop. ODR has been pushed to the forefront in this pandemic era. We have realized that technology can indeed to help to facilitate the dispute resolution process. In the last sessions, we have already discussed about the very important development of ODR in the last few years or last 2 decades. And also at the international level, we do see a lot of important development at the technical side and also regulatory side. But also we can see that ODR can really help the MSMEs. Now, we will look into very important aspects about the ODR service providers. So today we will have 3 distinguished speakers from 3 jurisdictions. Apart from Hong Kong, we have 2 jurisdictions from the ASEAN members, Hong Kong, Singapore, and Thailand. All of them have rich experience in ODR practice. Our first speaker is Ms. Emmanuel Ta, who is currently the CEO of Ibrahim International Online Dispute Resolution Center. She has over 15 years of experience in international arbitration and case management. Ms. Ta, you have the floor, please.
Thank you very much, Professor Zhao. We've heard this morning about the international and regional developments of ODR and how ODR can help traders in ASEAN to overcome the challenges they face in the resolution of cross-border disputes. In the next 15 minutes, I'd like to share with you our experience on the use of ODR in Hong Kong. But before I walk you through the key features of our platform, let me briefly introduce Ibrahim International Online Dispute Resolution Center and the law tech services that Ibrahim provides. Ibrahim is a non-profit company established in 2018 with the support of the Asian Academy of International Law, the Hong Kong Bar Association, and the Law Society of Hong Kong. Ibrahim's vision is to provide a one-stop shop platform for commercial parties from all over the world by providing a deal-making, e-mediation, and e-arbitration online platform using innovative technology. In June 2020, Ibrahim launched its ODR platform for COVID-19 related disputes following the introduction of the COVID-19 ODR scheme by the Hong Kong government. Ibrahim not only provides a platform to resolve disputes, but it also administers cases like any other arbitral institutions to ensure that the ODR process is conducted in accordance with Ibrahim's rules. Ibrahim has launched various sets of rules to regulate the ODR process for COVID-19 related disputes, for APEC B2B cross-border disputes, mediation, and arbitration. Ibrahim also appoints neutrals from its panel of mediators and arbitrators when the parties are unable to agree on one. Ibrahim is one of the 6 qualified institutions under the arrangement on interim measures signed between the mainland and Hong Kong. The arrangement allows parties to an arbitration administered by one of the qualified institutions and seated in Hong Kong to apply to PRC courts for interim relief against mainland-based counterparties. Therefore, parties to an online arbitration administered by Ibrahim and under Ibrahim's arbitration rules can benefit from this arrangement and seek assistance from the mainland courts to obtain interim measures, pre-arbitration process, or during the course of an arbitral proceeding. Ibrahim has developed video conferencing and e-signing systems and provides technical support for hearings and law-related events. Ibrahim's law tech services will include a highly compatible one-stop shop platform for businesses to negotiate a deal or resolve disputes online. Our platform complies with international cybersecurity requirements and is protected by the highest level of cloud security. We offer a multi-tiered dispute resolution service as well as a white label solution to users. In the next 2 slides, I am going to introduce the ODR platforms developed by Ibrahim under 2 schemes, the COVID-19 ODR scheme and the APEC Collaborative Framework for ODR. Ibrahim launched the COVID-19 ODR platform in June 2020. Under the scheme, the platform is applicable to disputes arising out of or in relation to COVID-19, cases where the claim amount is less than 500,000 Hong Kong dollars, and cases where one of the parties to the dispute is a Hong Kong resident or a Hong Kong company. The platform takes the form of an interactive website with video conferencing technology. It is available in traditional and simplified Chinese and English and adopts a 3-stage proceeding: negotiation, mediation, and arbitration. The ODR proceedings are governed by Ibrahim's rules for COVID-19 ODR scheme. Now turning to the APEC ODR platform. As Mike has mentioned in his presentation, Ibrahim is an ODR provider under the APEC Collaborative ODR Framework. And its role is to assist enterprises, in particular MSMEs, in the APEC economies to resolve cross-border business-to-business disputes speedily and cost-effectively by providing a reliable and secure platform. Our ODR platform is available for disputes under 500,000 Hong Kong dollars. However, parties may also use Ibrahim's APEC rules to resolve disputes involving more than 500,000 Hong Kong dollars. Ibrahim has launched its APEC rules, which comply with the APEC ODR framework and incorporate the APEC model procedural rules. Ibrahim is currently developing its APEC ODR platform, which will commence operation towards the end of the year. So ODR may present opportunities for businesses in ASEAN member states to resolve cross-border disputes with their partnering traders. 7 out of the 10 member states of ASEAN are also APEC economies. Therefore, they can also benefit from Ibrahim's APEC ODR rules to resolve cross-border disputes through a safe, convenient, and cost-effective ODR platform. Let me now walk you through Ibrahim's Apec Odr process. So in line with what John Chung and Mark Dennis have shared with you this morning, our platform adopts a multi-tiered ODR process with a three-stage proceeding: negotiation, mediation, and arbitration. Each stage of the proceedings will be completed within a short period of time. So from the filing of the notice to commence proceedings up to the settlement agreement or the rendering of an arbitral award, the parties and neutral will be required to exchange all communications and case submissions through the online case filing portal. And to facilitate the submission of the request for commencement of proceedings, the claimant will be able to file its notice to commence proceedings by completing an online notice directly on the platform. So in terms of efficiency, all files are organized and searchable and can be found in one place. Parties and neutrals can upload, view, download files anytime. The platform will be accessible on desktop, mobile, and tablet. The registration fee payable by the claimant to commence proceedings is 5,000 Hong Kong dollars. The platform will also provide a cost calculator that allows the parties to estimate the likely cost of a proceeding according to Ibrahim's schedule of fees. The cost calculator will generate the amounts for Ibrahim's administrative fees and for the neutral fees. In addition, any neutral will be appointed by Ibrahim to conduct the proceedings. Ibrahim will choose a suitable candidate from its panel of neutrals. Ibrahim's panel comprises of experienced mediators and arbitrators coming from different APEC economies and speaking the languages of the APEC economies. Now, what are the key features of Ibrahim's ODR platform? Our platform provides the parties and neutral with a convenient, efficient, and secure communication means for each stage of the proceedings. The platform includes functions such as a video conferencing system developed by Ibrahim, a calendar for relevant dates and deadlines, and a board for the neutral to communicate with the parties. Meetings, case management conferences, and hearings can be arranged through the platform, and video conferencing is available during the process to maximize efficiency and reduce cost. In terms of technology, the platform will include real-time transcription, e-bundle, e-signature. All documents exchanged through the platform will be saved on a highly secured cloud storage using blockchain technology to protect the integrity of all documents uploaded onto the platform. Our platform will also be available in Chinese and English, and later on made available in other languages spoken in the APEC economies. In addition to the COVID-19 and APEC ODR platforms, Ibrahim is also developing a standalone mediation and arbitration platform to provide fast, convenient, and secure ODR services at a reasonable fee without restrictions in terms of the location where the dispute has arisen, the nationality of the disputing parties, the type of the dispute, or the amount in dispute. Parties can opt for an online negotiation, e-mediation, or e-arbitration, or a combination of all three modes. In June 2021, Ibrahim has launched its mediation and arbitration rules, which can be found on Ibrahim's website. Ibrahim has also been working on other projects to enrich its law tech portfolio. Ibrahim is currently looking into developing Ibrahim's legal cloud portal to provide safe and affordable data storage services, as well as AI machine learning translation, e-transcription, and e-bundling systems, which will be new features to add to the existing and future platform. Ibrahim will also adopt advanced technologies such as blockchain, real-time translation to provide a deal-making platform. Through Ibrahim Online deal-making platform, parties from different locations can efficiently negotiate a deal by conducting meetings and sharing documents on the platform and conclude their agreement digitally. Now, let me share with you our experience with the COVID-19 ODR platform. The use of ODR was proposed on a number of occasions by the claimant. However, it has been difficult to obtain the respondent party's consent to use ODR to resolve the dispute between the parties. In other cases, the parties were able to settle their disputes shortly after the claimant has commenced proceedings by filing the case through our COVID-19 ODR platform. So based on our experience with the COVID-19 ODR platform, we note that small businesses in Hong Kong have been reluctant to use ODR to resolve their disputes, as they were not familiar with such form of process to resolve disputes. There may also be a misconception that ODR might be more suitable for legal professionals or large enterprises with in-house counsel. For instance, some users of our COVID-19 ODR platform had concerns about data privacy. Parties have refused to upload their identity card onto our platform during the registration process. In other cases, there were concerns about confidentiality that a third party, i.e. the service provider, would be aware of the dispute between the company and its client. So respondent parties have refused to use ODR to resolve the dispute. Parties have preferred to settle their dispute privately instead of using ODR. So in order to overcome these psychological barriers, recent initiatives have been taken to encourage and support the development of law tech and ODR. These are initiatives taken by the Hong Kong government and Ibrahim, and I'm going to mention them briefly. The Chief Executive's 2018 policy address recognized the importance of developing law tech. In April 2020, the Hong Kong government introduced the COVID-19 ODR scheme to provide a speedy and cost-effective means for the general public and businesses in Hong Kong to resolve COVID-19 related low-value disputes. As mentioned earlier, Ibrahim has been engaged as the ODR provider under this scheme. Further, in April 2021, Hong Kong-China opted into the Asia-Pacific Economic Cooperation, APEC, collaborative ODR framework. Ibrahim is an ODR provider under this framework. All these recent initiatives reflect Hong Kong government's continuous efforts and commitment to encourage the use of ODR in the provision of dispute resolution services. Now moving to Ibrahim's initiatives. Ibrahim has provided e-mediator training sessions to local legal professionals and has been engaged in advertising campaigns to raise awareness and promote the use of ODR. Under the COVID-19 ODR scheme, Ibrahim trained more than 150 mediators and arbitrators. They came from diverse backgrounds and different jurisdictions, including Hong Kong, the United Kingdom, Australia, India, and Singapore. We are also seeing international and regional organizations such as the UNCITRAL and APEC that are taking steps to promote the use of ODR and the development of a platform for ADR. To conclude, let me give you a quick overview of Ibrahim's roadmap for its law tech services that businesses within the ASEAN countries may benefit from. The APEC ODR framework platform to be launched by the end of December, and Ibrahim standalone mediation and arbitration platforms in the second quarter of 2022. As a forerunner in law tech, Ibrahim will continue to integrate the latest technology to enhance its platform and systems. Ibrahim welcomes feedback and comments from users and stakeholders to ensure that its services meet their expectations. And as part of its ongoing efforts to promote ODR, Ibrahim will continue to engage in capacity building, raise awareness, and promote the use of ODR in the region and beyond. To learn more about Ibrahim, please visit our website by scanning the QR code that appears on the screen. My team and I are available by email and phone for any queries you may have. Thank you.
Thank you, Mr. for your sharing with us e-brand and also very important scheme. I think COVID-19 scheme. Definitely, I think this scheme is a very important step for the development of the platform, the online dispute resolution services. e-brand was launched in 2018. I think I can see, I think in the last few years, I think quite some development has been made. Of course, I think we can see that e-brand will continue to serve as a pillar for Hong Kong to be the International Dispute Resolution Center. So I think online dispute resolution will be indispensable. So I'm sure that with your leadership, I understand, you assumed the role, 2 or 3 months ago. So I'm pleased that you already have a clear roadmap, for the ODR, for the Ibrahim to further develop. So now may I move to the second speaker. Our second speaker is Professor Nadia Alexander, who is a professor of law practice and director of the Singapore International Dispute Resolution Academy at Singapore Management University. Nadia has an international portfolio, having been engaged in dispute resolution work in more than 40 countries. I have also the pleasure to work with her on the Apec Odr collaborative framework as lead academics. So now let me pass the floor to Nadia.
Thank you very, very much. Thank you to the Department of Justice for putting on this wonderful event. It's a pleasure and a privilege to be presenting and sharing with you today. Can I check that you can see my slides? Yes, I've got a nod. All right. So I think the timing, this wasn't planned, but the timing of these presentations, the order is fantastic, because a lot of what was said by Ms. Ta throughout her presentation on Ibrahim, I hope will be relevant with what I want to say. So far today, also in the other sessions, we've had people talking about the technology, about different ODR platforms. We've now had a deep dive into Ibrahim. We've had a look at the perspective of the MSCs, and I want to take a slightly different direction and look at how mediation specifically, and I want to focus on mediation because I think I can do a more hopefully meaningful presentation by focusing on one procedure, how mediation transforms when it's digitized or can transform, and some factors that we might need to, or providers might need to look out for. Now, let me just move on. I want to make 2 main points. One is I want to highlight the vulnerability of flexible dispute resolution procedures such as mediation when they're subject to rapid digitization. And by that, I'm really referring to the whole COVID experience. And I'm taking a global perspective here. That a lot of providers have moved very quickly online, offering mediation online, and what have the implications of that been. And then I also want to highlight some factors that I think are critical to transitioning mediation online or in a digital form, and doing so with integrity to the principles of that process. And of course, you could have this discussion in relation to any ODR or any dispute resolution process as well. So now just for a little bit of a background, we've spoken about the pandemic. Mediation has been dubbed by some commentators as a pandemic-proof process. Why? Because it's shown itself to be highly adaptable to changes, legal changes, economic changes, political, socio-cultural changes. And as a dispute resolution process, mediation is really characterized by its agility in procedure, by its responsiveness to different cultures, by its client-centeredness, its focus on party autonomy, and by its collaborative principles of negotiation and decision-making, amongst others. And users, the research shows, including research that we've conducted at CIDRA, that users of dispute resolution like these factors when it comes to mediation, and they also like the cost and time efficiencies, which I know other speakers have spoken about. And mediation is also, I think, particularly suitable to some types of disputes that are emerging out of this pandemic and which are due to the fault of neither party, right? They've emerged because of disruptions in supply chains or frustration of a wide range of business arrangements because of travel restrictions, etc. Because of course, of its collaborative and client-centered principles. And I think service providers, whether they be dispute resolution institutions, ODR providers, but also individual mediators, play a really important role in shaping the mediation processes of the future. And in fact, we all, if we're involved in mediation or any type of dispute resolution, we're all doing some ODR, right? Because most of us are on email at least, and many of us may be conducting at least preliminary meetings online or conducting the case filing part or pre-mediation in some sort of digitized form. So we're there anyway. It's not all ODR or all face-to-face. It's usually a continuum. And what I think we've noticed, and of course this doesn't apply to Ibrahim, but what we've noticed from a global perspective is that many providers who've gone online have, despite the existence of many dedicated ODR platforms that have been around for quite a while, many providers have gravitated towards social communication platforms, such as the one we're using today, Zoom, or Teams, or other ones as well. And that's understandable, because all of a sudden we're doing everything on Zoom. We're visiting relatives, we're conducting meetings, and we're sorting out our problems. It makes sense. But I think it's not an end solution, because when you start to shift, if you think of mediation as a flexible process with variations and different models, once you move it online, and we've seen that from the previous speakers looking at the different types of technology, that flexibility increases dramatically. So online mediation can have very, very many different faces, and it can powerfully shift the very nature of the process, what it looks like, what it feels like. It can shift the power dynamics. And I think that's something that's important to all users, but also particularly important to MSMEs. So the question I want to ask is, how do service providers know that they're digitally ready, or how can they become digitally ready? What does it mean to be digitally ready to offer dispute resolution or mediation in particular? And also from a user perspective, how do I know which ODR platform or which online mediation platform is suitable for me? Now, I'm not going to go through, many speakers have done this before, some of the types of technology we're looking at are facilitated negotiation, automated negotiation, negotiation support systems, and extended reality, virtual reality, augmented reality. What I want to focus on is three, I've just realized I've got everybody up here. Sorry, let me try and move this. Three critical factors for the success of mediation in moving online. And these three factors have come not from any online survey, but they're asking what's important in dispute resolution through mediation anyway, and how can we move these three factors, which users have said are important in physical face-to-face mediation, how can we make sure they make the transition into whatever online or digital format we have? And these three factors are user-centeredness, reliability, and accessibility. And in the time that I have, I just want to say a few words about each of those. I mean, I could go into a lot more detail, which I won't, about how they were categorized and how they came from the data, but I think suffice to say they've come from surveys of users of cross-border mediation. So when we talk about user-centeredness in mediation generally, right, we're talking about the impartiality of the forum, maximizing party self-determination through this type of impartial, trusted forum. We're talking about transparency, efficient processes and outputs. That's something that users want, and the focus and their input into the process and the output, and also procedural flexibility, again, to meet the needs and requests of the users. And so what does it mean when we shift that online? And I think, in describing Ibrahim, Ms. Tar talked about a lot of these different factors. So, I mean, if you like, you can recall what she was talking about as we go briefly through these factors. In terms of online mediation systems and impartiality, amongst other things, we've got to make sure that offline privileges and disadvantages aren't replicated in an online system. We need to look at provision for cultural differences. And we need to use technology in a way that maximizes informed decision-making, right? And how does the technology do that? In terms of transparency, we've got to balance, transparency against privacy and confidentiality, right? And what are the policies of the online dispute resolution platform in relation to that? And what of the role of system administrators, right, and other people who have access to the data and to the technology? In terms of processes, in terms of efficiency of process, efficient process and output, the use of integrated case management that allows for online case filing and payment where users can efficiently manage their cases digitally, right? The use of recorded mediated settlement agreements and the ability to sign online and have those stored in a confidential space. And I think you may be recalling some comments from the last presentation on this as well. And in terms of procedural flexibility, does the ODR platform still maintain that flexibility, right? Or does it restrict or limit flexibility? If we're saying that user-centeredness means we have a flexible process, how does the technology or the platform keep that flexibility there, right? Or does it put users in a technological straitjacket? Oops, here we go. And what of reliability, right? Reliability in the online space, yes, it's about security, it's about confidentiality. It's about users being informed of any unintended breaches of security in a timely manner. It's about appropriate cyber security and data protection protocols. But it's also about regulatory robustness and accountability. So how does the online system comply with applicable law, right? Does it have the ability to automate compliance with mediated settlement agreements, for example? Is it accountable to the institutional mediation provider? Is it accountable to the user? And if so, how? And what about maintenance? What about responsiveness? What about technical help? What about competency that your mediator has the skills not just to mediate, but also to manage the technology? And what about, well, this is probably linking to the next point on accessibility, and Ms. Tara also mentioned this point. What about accessibility in terms of training the users or having tools that the users can access to help them use these platforms in a better, more efficient way? And of course, accessibility in an online world means not just geographical accessibility or financial accessibility, but digital literacy, digital accessibility, linguistic accessibility, which can be made easier online, of course, and user capacity building, right? So to what extent is the online mediation provider, and this might be really, I think, important for MSEs, to what extent do they offer or provide or make available access to information, guidance, and training about the process mediation, right? About how to use this technology, about how to prepare for a mediation process. To what extent are there dispute analysis tools there? So these are just some ideas, and I know I've raced through them quickly, but the idea I really wanted to share with you is that we can't just try and emulate what we do offline in mediation online. Once we do that, it changes, right? In online mediation, just through video conferencing, for example, you can do concurrent caucusing, right? You can be having 2 private sessions at the same time with 2 parties, which completely changes the dynamic. And to what extent do you tell parties that you're doing this? In a physical setting, each party knows when a mediator is having a caucus with the other. I mean, that's just one tiny example, right? Certain technologies will favor certain users, but be disadvantageous to others, right? And the idea of these 3 touchstones, user-centeredness, reliability, and accessibility, are really there for service providers, particularly institutional service providers, to think through, right, before they invest in a technology or choose a particular platform, that they want to use. And if they are using Zoom or Teams or a regular social communication platform, I think they really, owe it to the users to go through these issues and be able to answer them for themselves and for their clients. Thank you very much.
Thank you, Nadia, for sharing with us your ODR experience, in particular in the field of online mediation. I think the three critical factors that you have just mentioned, the usability, reliability, and accessibility, are no doubt very important to build or probably to gain the confidence from the users of ODR. So now our third speaker is from Thailand, Ms. Phun Prasert. She is a legal counsel of the Thailand Arbitration Center. Thailand has been very actively involved in the ODR process in the past few years, including the Apec Odr Collaborative Framework. As important member states of the ASEAN, I'm sure that the experience from Thailand will be most helpful and useful for other ASEAN members. So, Ms. Phun Prasert, you have the floor.
Thank you. Hi. Okay. Can you see my slide? Okay. Thank you for having me today. So today I would like to share the experience about ODR in Thailand. Nowadays, as you can see, it's easier to access the internet. So we found that Thailand internet user has extremely been grow, and Thai people spend time for using the internet almost 9 hours a day. So with trend increasing in every year. So TSSC realized this opportunity, and so we had created our own ODR platform, so which we call TalkDD. So TalkDD was established in 2016, and TSSC are the first pioneer of ODR platform in Thailand. At the first time that we have ODR platform, we just only focus on e-commerce market, because we thought that Thai people use the internet for online shopping from eBay or Amazon. But in the real life, we found that Thai behavior prefer to shop online shopping through the social media like Facebook or Instagram. And so all this behavior, we have realized that the first version on ODR platform did not cover all disputes. So after TSSC had developed the ODR platform in order to cover with current situation, and we can able to serve variety case for the user. So when we had developed the new platform, we had add more option and more feature in order to support the variety case. At the first time, we just have only a mediation case, but when we developed the platform, now we have a conciliation case and arbitration case as well. And TalkDD has a high reasonable fee, and the platform also has a high security and confidentially. Okay, and so this feature, the user can escalate the type of the dispute, and this make the more option for the user. So moreover, our TalkDD platform to support in multiple languages for serving Thai and foreigners people as well, such as Thai language, English, Chinese, and including Russians. And now you can see we have cooperated with Thailand. Excuse me. Okay. Sorry. And now TSSC has cooperated with Thailand Ministry of E-Commerce to taking care of intellectual property cases such as trademark and patents case. And now then we had a TSSC online dispute resolution rule to support the platform and the users as well. So all we had to do is the development, the platform is make opportunity for us because we have more any cases that use ODR platform to resolve the dispute. But there are some challenges that we have to face too. The first challenges that we face is the email. We have to accept that in Thailand, the email is not the main communication channel at all. Mostly the Thai people use phone call or chat application to communicate with each other. So due to information requirement, ODR platform or TalkDD required to provide email address of the both party. Sometimes we found some user has no email address. So this is the reason that we can't proceed into the next step. And sometimes the user requests our team to register the email address and check the email address and follow up the process for them. And the second challenge that we face is the complicated cases. Because of the limitation of resource, we found that our ODR or TalkDD platform suit with simple cases that no high volume claims. So if the party would like to submit the case that they have a high volume case, we just recommend them to submit the case by face-to-face instead of visual method. However, I believe that in the future, online dispute resolution or ODR platform will be known and popular to resolve the disputes in Thailand because TSSC has a lot of campaign to promote the ODR or TalkDD or educate the people how to use the ODR platform. And I hope that ODR platform is the best one of the option to the user because this platform is flexible and faster. Thank you.
Thank you, Ms. Poon Prasad, for your very interesting presentations on the online platform TalkDD, which my feeling is that it's quite Thai-oriented. Of course, I think very interesting. The efficiency and the effectiveness demonstrated by this platform, as you have just demonstrated, will no doubt push further development of the ODR services in Thailand and beyond. Now, I think we will still have some time for Q&A. I have received several questions. Possibly, I pick up one question for all the three speakers first. Then we will see whether we still have more time for Q&A. One major question is, please suggest some ways that ODR platforms can help traders, including MSMEs, to recover from the economic attacks brought by the pandemic. I assume Ms. Ta will have to be the first person to answer. I assume you will start with a COVID-19 scheme.
Yeah,
yes,
so we have a COVID-19 scheme, a platform for the general public and businesses to resolve COVID-19 related disputes. And for the Apec ODR platform, it is also a secure and convenient platform for parties to use. We provide guidance to small businesses, MSMEs or general public as to how they can file the notice online. There are questions that we ask, when they register on the platform, and to guide them through the process, how to fill in the notice of commencement of proceedings. And throughout the proceedings, so as I've mentioned in my presentation, they will have to use our platform to communicate, to upload their submissions, their documents, their evidence, and everything will be stored in one place. And Ibrahim's center will be there to assist the parties and neutrals throughout the proceedings. So assistance will be provided as well, and we also help, break the language barriers within the ASEAN countries. The platform will be available in many languages.
Thank you. Nadia, please.
Hi, look, I don't have a lot to add to that. I think there's an enormous amount to be done in terms of reaching out to the MSME communities, capacity building, offering services that are, that are available, that are accessible, and doing information training or awareness building in all sorts of ways. I think this sort of multi-pronged approach really is the best way to go. And I think it's an ongoing task and challenge.
Yeah, thank you. So Ms. Poon Placet.
Can you hear me?
Yes, we can.
Sorry, can I have a questions again?
The question is, what ways that the ODR platform can help the MSMEs, which has been suffering from the pandemic?
The challenge, right? I think ODR platform has multiple languages to support the user, and I think the challenge is the email that the user, some user has no email. So this is my challenge. Challenges that we have to improve and educate the people that use more email address. Thank you.
Yeah, thank you, Ms. Poon Placet. May I follow up with one small question? I think, as I have just mentioned, TalkDD is quite Thai-oriented, which of course I think works very well in Thailand. I'm not too sure, I think, whether you have any plan to further expand to other ASEAN countries, and if so, how you will update this platform.
Okay. So in the future, TSSC have promote the TalkDD platform to the ASEAN to support the user that have the problem that they can use the TalkDD platform to resolve the problem by promoting the TalkDD at the social media, and we have promote and educate the user to how to use the TalkDD platform that is easy and flexible and faster than face-to-face resolve the problem. Thank you.
Yeah, thank you. Thank you very much. Ladies and gentlemen, the three distinguished panel members have already shared their views and also gave excellent presentations. I think one message is quite clear to all of us. I think ODR is the future. ODR is an irreversible change. We can see the technology really can help us in the facilitation of dispute resolution process. But we also can find out that the pandemic era indeed provides an excellent opportunity for the development of ODR. But even after the pandemic era, after the end of the pandemic, I'm sure ODR will continue to develop. At a national level, we have already seen the establishment of important ODR platform already in the past few years. But at the international level, we can also see the initiatives from international intergovernmental organizations by setting up groups to study possible regulatory framework for the smooth development and healthy development of ODR. So I'm very pleased to see that we have some kind of consensus today. I think actually Michael Dennis, James Dean, and also other speakers have already mentioned that capacity building is rather important. I'm sure a lot of work needs to be done in the near future on how to promote ODR, how to win the trust, how to gain the confidence from the users of ODR. So I think that's one very clear message that we can gain today. So with this, I think before I conclude my session, I would also like to thank the three speakers for excellent sharing. May I invite all of you to join me by thanking these three speakers. Thank you very much.
Thank you, Professor Zhao and the speakers. Let's take a moment and take a quick photo. And also our speakers online. 3, 2, 1. Cheers. And one more, right? Okay, one more photo. Another count of 3, 3, 2, 1. Thank you once again. Thank you, Professor Zhao, Dr. Alexander, Ms. Ponprocet, and Ms. Ta for the inspirational sharing and discussion. To conclude today's workshop, we are honored to have Mr. Lui Tae-kyung, Head of Competition, Consumer Protection and Intellectual Property Rights Division of the ASEAN Secretariat, to deliver the closing remarks. And our moderator and speakers, thank you very much once again. Please be seated. Let's give a big hand and welcome Mr. Lui. Thank you.
Thank you very much. Honorable Ms. Teresa Cheng Yok-Hwa, Secretary of Justice of Hong Kong, China, colleagues from the Department of Justice, Hong Kong SAR, distinguished guest speakers and participants, ladies and gentlemen, good afternoon. It is with great pleasure and honor for me to deliver the closing remarks to conclude today's ODR workshop. The insights received and knowledge gained is invaluable. Given the importance of ODR in a growing digital economy, let me share with you the initiatives taken by ASEAN to address the ODR needs as encapsulated in the ASEAN high-level principles of consumer protection, specifically high-level principle 4 to ensure consumers have access to appropriate, convenient sources of advice and redress, including alternative dispute resolution, and high-level principle 8 to ensure consumers in e-commerce are protected. Next slide, please. Now, at the 53rd ASEAN Economic Ministers meeting on 8 to 9 September 2021, the ministers considered the strategies and steps needed to accelerate ASEAN's economic recovery, digital economy integration, and the work plan for the implementation of the now endorsed ASEAN Agreement on e-commerce. The consolidated strategy of the ASEAN Fourth Industrial Revolution was also discussed. Among others, ODR being the online version of ADR are considered instrumental to maximize growth potential of digital trade in ASEAN, as it helps spur the growth of e-commerce and instill consumer confidence in the digital economy. At the AEM, the ASEAN Digital Integration Framework Action Plan 2019 to 2025 was launched together with the ASEAN Digital Integration Index. Together, they serve as an action plan, as an index, which can be used to measure the progress of digital integration of trade services in ASEAN. The AEM endorsed the Bandar Seri Begawan Roadmap, an ASEAN digital transformation agenda to accelerate ASEAN's economic recovery and digital economic integration, the BSBR. In the BSBR, the ASEAN ODR network is identified as part of Phase 2, Measure 1, to accelerate existing work in the area of trade facilitation and digitalization, which calls for the development and implementation of the ASEAN ODR mechanism for cross-border consumer complaints. Next slide, please. Let me highlight to you, ladies and gentlemen, the specific deliverables under our ASEAN Strategic Action Plan on Consumer Protection, ASPCP 2016-25, which was earlier highlighted by the Secretary of Justice, the Honorable Teresa Cheng, in her opening remarks. That deals with the development of ODR in ASEAN. Other than the two high-level principles mentioned earlier, being part of the high-level principles on consumer protection set out as Initiative 1.1.1 of the ASPCP, we are to achieve Outcome 3.2, which is to establish an ASEAN regional ODR network by implementing 3 specific initiatives. These are namely Initiative 3.2.1 to establish the national ODR system, Initiative 3.2.2 to establish the ASEAN ODR network, and Initiative 3.2.3 to establish an ASEAN mechanism for cross-border complaints and investigations. These initiatives are supplemented by the now completed initiatives 1.6.1 to develop the guidelines to common approaches on ADR for consumer protection, and the feasibility study on the ASEAN ODR network. Having received confirmation that an ODR ASEAN network can be developed with multiple models, we are now developing an ASEAN ODR guidelines to help AMS to develop their respective ODR. Concurrently, we are also undertaking as Initiative 2.1.1, a study on the needs and gaps in AMS on the access to consumer redress. We are also completing a pilot or trial run of an ASEAN regional complaint system as identified earlier in the BSDR. All these initiatives strive towards instituting high consumer confidence in the ASEAN economic community and cross-border commercial transactions as encapsulated in strategic goal 3 of our ASPCP. Now, when developed and proven successful, the ASEAN ODR network can extend to B2B, not just B2C, and can also be extended to other sectors. The ASEAN ODR guidelines, once completed, will set the benchmark for all AMS in establishing their respective ODR. We should pave the way towards interoperability and convergence with harmonization of consumer laws and policies in the longer term. The ADR guidelines mentioned earlier assesses the different approaches in ADR in each AMS and recommends steps to facilitate its implementation. The needs and gaps study would also help AMS considering reforms within its legal redress mechanism, e-commerce, fintech, and data protection sector. Next slide, please. This slide basically sets out the various complexity and degree of automation which the ODR system can have, from simple, straightforward digital filing in a simple platform on the one hand to the highly sophisticated predictive justice that functions based on algorithm AI, which can be data-driven without human intervention. The diversity in this system approaches has been dealt with by our excellent panelists, specifically Mr. John Chung in the first session on introduction to ODR, and the variety of processes such as mediation, as highlighted by Dr. Nadia Alexander in the last session, which could also be emphasized in its delivery for the benefit of MSMEs. Our ODR feasibility studies informs us that it is not necessary that we should start off with the most sophisticated technology or advanced digital platform or fastest connectivity in order to establish a functional ODR system domestically or regionally to service consumers or businesses with cross-border disputes. In fact, using simple emails or having a basic platform to file regional consumer complaints, which is then automatically redistributed to participating AMS consumer protection agencies, as we have done under a pilot or trial study, is sufficient to streamline and manage the commoditized nature of consumer complaints. Over time, of course, as the technology improves and become more affordable, we can consider systems upgrade. Next slide, please. Distinguished ladies and gentlemen, so how exactly will the ASEAN ODR network look like? In theory, it should be something modular, similar to the puzzle shown here, which each different puzzle piece representing an important segment of the economic landscape. These are the traditional offline modes of dispute resolution, including non-litigation channels, the business and consumer associations, the available ODR mechanisms for specific sectors such as finance, food safety, tourism, the utilization of the ACCP website. In other words, there is a built-in interoperability from the design stage. The ACCP, which is the ASEAN Committee for Consumer Protection focal point, would be responsible for coordination and referral across and within countries, engage in facilitation and mediation, especially those involving vulnerable consumers, and data management. This modular design can be stacked up once the ODR are expanded to other sectors or new industries. Next slide, please. Permit me, ladies and gentlemen, to explain the vision of the regional ASEAN ODR network by way of a colored panel flowchart. In a nutshell, the blue panel refers to the regional ODR network, which is headed by the ACCP focal points and the ASEAN Secretariat. It is connected to the AMS National ODR in the orange panel and the respective sub-national ODR in the green panel, comprising the usual consumer protection agencies, sectoral authorities, consumer associations, ADR bodies, and tribunals. The white boxes refers to traditional ADR with brick and mortar setup, slowly being converted into online dispute resolution represented by the yellow boxes. It is an ongoing process happening in all AMS with differing number of yellow and white boxes. The aim is eventually to convert the whites into yellow and eventually link to the large yellow box in the blue regional panel. And as rightly pointed out by Mr. Francis Ho in the second session, requires the collaboration of all stakeholders for the ODR system to work. Next slide, please. Distinguished ladies and gentlemen, please allow me to elaborate a little on the progress of the ODR system, which have been developed by some AMS and add on to what have been discussed at the workshop today. A good example is the ODR developed by the Office of the Consumer Protection Board, OCPB, in Thailand, which set up an online mediation platform which currently focuses on the automotive sector. It is a pilot project where consumers may lodge their complaint through website using mobile application or offline means, such as the complaint centers and hotline. The option for settlement through online mediation is voluntary. If both parties agree to use the online mediation, the mediator from the OCPB will approach them to set a time and date for a virtual meeting. A confirmation along with a password for access will be communicated through SMS or email. If the mediation process is successful, the complaint will be terminated from the system and both parties will be required to sign an agreement. Whether or not the parties follow through on this agreement is closely monitored by the OCPB. On the other hand, if the initial mediation fails, another online mediator will be appointed to assist with the settlement of the complaint. Although this ODR system is currently still in a pilot phase, there are already plans to expand it to more sectors or industries. Once all technicalities are solved and an initial track record of successful mediation outcomes has been established. The automotive sector was selected because of the high volume and the value of cases. The creation of this particular ODR mechanism is a good and humble start with the end point of eventually developing an ASEAN ODR network. It was great to hear Ms. Pechlada Pungpratsat, Council of Thailand Arbitration Center or THAC, describe the development of their ODR system, Talk DD. And we commend the effort for this initiative, especially multi-language function, which covers Thai, English, Chinese, and Russian. As mentioned earlier, recently the ACCP website piloted the ACCP online consumer complaints function during the ASEAN Online Sale Day, which took place in August 2021. This pilot function allows consumers who have purchased products within ASEAN to lodge a complaint through the ACCP website, where focal points assigned to each AMS will be notified. Complaints can originate from any consumers around the world who has purchased a product from one of the AMS. Once a complaint is lodged, a consumer protection agency from the AMS of where the product originates will follow up with the complainant and commence the investigations until the dispute has been resolved. Next are the AMS who are currently building their own ODR mechanisms, such as the Philippines, as ably elaborated by Attorney D.T. Elgo of the DOJ Office of ADR in the second session, which envisaged an online automated portal for consumer complaints and queries. Shifting from a manual and email referral system, the platform will allow consumers to track their complaints processing in real time and link up with all consumer-related agencies outside of their DTI so that cases under their respective purview could be dealt with in the fastest manner. All of these systems do correspond with the common criteria and recommendation of an initial ASEAN ODR mechanism design. You'd like to know more about this, you may look through the ASEAN ODR feasibility study available for download at our ASEANconsumer.org website. Others in the pipeline are being developed are Indonesia, which is linked with the e-commerce platforms, and the cases are closely monitored. In the case of Vietnam, the progress of dispute resolution can be tracked online regardless of location in the country, and is set to be the basis of a more sophisticated system in the future. We also note the great work that's being done by Ibrahim, as ably presented by Ms. Puiki Emmanuel Ta. Next slide, please. Distinguished ladies and gentlemen, allow me to just say a few words about the opportunities and challenges in developing an ODR network in ASEAN. It's obvious what the opportunities are. This includes having access to a dispute resolution mechanism in the hands of consumers and businesses with one click. There is no more need for snail mail and often frustrating phone calls and helplines. The ODR enables bulk consumer claims to be processed with some degree of automation and standardization, addresses low value and high volume complaints in the business world. Given the technology efficiency, the marginal cost for every additional complaint is very low and sometimes can even approximate zero, resulting in lower operating costs in the longer run, thus financially sustainable, not to mention with legal certainty and consistency of outcomes for businesses and consumers, and also which is as rightly pointed out by Mr. Michael Danis in first session. However, the challenges are many. The principal challenge is political willpower and the sunk cost of human resource and infrastructure. Other than that, data protection, cybersecurity, fairness by design, internet connectivity could be overcome with sufficient expertise, which is widely available. And in the earlier stages, this dispute may be appropriate for only specific type of disputes, such as food, travel, and hotel claims or the retail industries. Certain specific skill and contextual information would be required in addition to checks and balances in order to ensure that the ODR is functional in the longer term. Challenges, however, remains especially in the context of multi-party and multi-jurisdictional disputes and the lack of awareness of business and consumers on the effectiveness and importance of ODR, as pointed out by Mr. David Dobwell in the second session, on challenges for MSMEs in cross-border disputes. Next slide, please. Distinguished ladies and gentlemen, the development of the ODR in ASEAN is still at a nascent stage, as rightly observed too by Attorney D.T. Elogog during her intervention. This is notwithstanding that some AMS may have taken initiative to develop the national ODRs. The next milestone for the ACCP is to complete the ASEAN ODR guidelines, which are based on international best practices, such as the Municipal ODR Procedural Notes, EU ODR regulations, by end of this year. By the first quarter of next year, we expect to complete a study on needs and gaps in access to dispute resolution and redress system in ASEAN. After that, AMS that are ready would proceed to establish their respective ODR, adding to those that have already started or in the process of developing theirs. These are national milestones to be driven by the respective consumer protection agencies in the AMS with the support of dialogue partners. Once a critical number of AMS have developed their ODR, we would be able to establish an ASEAN ODR network according to the model set out in our feasibility study. Our target is to have this ASEAN ODR network be online by 2025, as provided in our ASEAN Strategic Action Plan for Consumer Protection, earlier if possible. Until then, and as rightly pointed out by our excellent panelists, such as Dr. James Ding and Michael Dennis in the first session, more capacity building activities should be developed and delivered. And awareness enhancement and amongst businesses on the importance of ODR, as emphasized by Mr. Francis Ho and Mr. David Dobwell in the second session. And also especially, as highlighted by Professor Bian Yong-min, that for lawyers to adopt ODR and to recommend this mode of settlement instead of high-cost litigation to the clients. There's much more work to be done ahead, and perhaps the vision of a global ODR platform, as highlighted by Professor Hoshihisa Hayakawa in his intervention, could be realized one day. And finally, as rightly pointed out by Professor Jajun, the ODR is the future. After all, the digital economy is completely borderless and totally incompatible with a geographical and nationally based legislative framework. Last slide, please. Before I end, please permit me in closing to thank once again the Secretary of Justice, the Honorable Ms. Teresa Cheng, for opening remarks. Allow me also to thank the following panelists for the session on Introduction to ODR and its international regional developments, Dr. James Ding, Mr. John Chung, Mr. Michael Dennis, Professor Yoshihiya Hayakawa. And in speaking on the topic challenges traders face in cross-border dispute resolution and how ODR can help, please allow me to thank Mr. Francis Ho, Attorney Irene D.T. Aloko, Professor Bian Yong-min, Mr. David Dobwell. And on the last topic, the experience sharing portion on using ODR, I would like to thank Professor Zhao Yun, Dr. Nadia Alexander, Ms. Pechlada Pung Prasad, and Ms. Pui Ki Emmanuel Ta. Lastly, I would also like to thank the rest of the colleagues from the Department of Justice of Hong Kong for organizing this workshop and all attendees with us today. I hope that everyone has benefited greatly from the knowledge and discussion shared. If you'd like to have more information on our progress, ACCP's progress in ADR and ODR in ASEAN, please follow us at our website at www.aseanconsumer.org. Once again, thank you very much for having me to present the closing remarks on behalf of the ASEAN Secretariat. We look forward to the collaboration between ASEAN and Hong Kong, China. Please stay safe and healthy. Thank you very much.
Thank you very much, Mr. Loy. Ladies and gentlemen, the workshop on ODR has come to an end. On behalf of the Department of Justice, we would like to thank all of our wonderful speakers and moderators for your insightful exchanges. And thank you for attending the workshop, for making this event a success. We would also like to express our gratitude to our supporting organizer, the Asian Academy of International Law, and the supporting organizer of the Hong Kong Legal Week 2021 in Invest Hong Kong. Before you leave, please remember to return your headsets and complete the evaluation form by scanning the QR code. For online participants, please fill out the online evaluation form. We hope to see you all once again in Hong Kong next year at phase 2 of the workshop. I'm Eunice. Thank you and goodbye. See you later.